Use the microphone. We have not heard.
Yes. To CRP, I use my lord. I am for the respondent when there is interim order, my lord. So, my lord, that was fixed after vacation
21.
on 26 May.
Please, my lord. My lord, there is a very urgent matter in connection with one execution proceedings. Execution proceedings is scheduled to be carried out on 24/7. That is the Monday. But my lord, in connection with this execution proceedings, I have filed a petition before the court below to stay for some time because I was not made a party, neither as a plaintiff nor as the defendant. But in connection with my suit line, when I have come to know that the proceeding is going on, that is the execution proceedings, thereafter, after coming to my knowledge, I have filed this first appeal. So, my lord, I submit that this matter may come tomorrow, my lord, because it is a very urgent matter and execution proceeding is very well initiated, in spite of my objection raised before.
You are not a party to the suit.
My lord.
You are not a party to the suit.
Another party, my lord.
Where you are party to the suit?
No, my lord. I am not. I was not made the party.
Then you have
My lord,
under the CPC
my lord,
2197.
my lord, it's because it is my land, it's because I am residing over the land.
In a suit where you are not a party.
My lord, that is why I filed the appeal. But my lord, this is a very urgent matter and may kindly be allowed to be listed tomorrow, my lord, at least for.
Whether the appeal is maintainable.
Appeal is maintainable because as per the Honorable Supreme Court's version passed very recently that if any person is affected, whether he may be plaintiff or he may not be defendant, or if he is not at all a party, then even he can intervene into the proceedings only by way of appeal.
Order 21 Rule 97.
Yes, my lord. My lord, there is a one Supreme Court judgment I am also having in my my lord. My lord, recent judgment in civil appeal number 5784 in My Palace Mutually Aided Cooperative Society versus Mason others. It was decided in this case, my lord, that even if anyone is not a party, but if he is affected, if his property is involved in the matter, then with the leave of the Honorable High Court, he can prefer the appeal. So that is why I have filed the appeal, my lord.
Leave.
My lord, I have filed an IA application along with my appeal. And along with some stay matter is also there. There are 3 IS petitions. So matter is very much urgent, my lord, because I have no other alternative to approach, my lord.
Have it tomorrow. Have it tomorrow.
Tomorrow.
Lordship, I beg to mention item number 10, Lordship.
Item number
10, Lordship.
10.
Lordship may not taken up this matter, Lordship. Matter may be taken up another bench, Lordship.
Yes. Please before I leave the bench without me. Yes.
May it please your lordship. But I have a prayer for accommodation of item number 11, 12. In this matter, the senior counsel DC Das has been engaged. But he is out of town. Can it be any?
13-14 matters.
I understand, my lord. In fact, we were pursuing to get it listed before the vacation, my lord. It has been listed now. And the senior counsel
When is he coming back?
3rd of August, my lord.
You're for the respondent.
In item number 12, I am for the appellant, my lord.
And in the 12,
In
11,
11, I am the respondent.
who's for the other side?
Mr. PP Das, who was there, I have taken his consent yesterday.
3B contemplated counsel submit that senior counsel BC Das has been engaged, who however is out of the present. He accordingly placed for an adjournment. In the interest of justice, list on
3rd of August, ma'am.
3rd of August.
Deeply obliged, ma'am.
May it please your lordship. So with the consent of the other side, I beg to mention item number 18, Lordship. This matter may kindly pass over for the day, Lordship. I am for the respondent insurance company. I've taken the consent, Lord.
What is your name?
SP Sharma, Lord.
On the prayer of SP Sharma, let it count for the respondent. Matter is adjourned to be listed after a week.
May I have lordship, lordship, we actually mentioned item number 2 lordship. It's a matter to be taken the adjournment lordship as because my senior is a D Mozumdar and opposite party is a BC Das. BC is out of station lordship. So matter may be taken up after Independence Day lordship, 15 lordship, after 2 weeks lordship, if possible lordship.
Why is the problem? What is the problem today?
Lordship, my senior is a D Mozumdar
Yes.
and the opposite party is a BC Das lordship.
Yes.
So BC Das is out of station. I have taken the consent lordship.
So the other side is out of station. What is your difficulty?
Lordship,
They have not
my
got-
seniors are not prepared today, sir lordship.
Tell us,
Yes,
you
lordship.
cannot take the advantage of the absence of other parties. They have not.
My seniors are not prepared today, sir lordship. So that's why lordship.
When do you want?
Lordship, after 2 weeks lordship, any of the day lordship.
A prayer for adjournment has been made by Sri R.C. Das, Planet Council for the petition. Matter is accordingly adjourned. To be listed on 4th of August. 4th August,
My interim order to be continued lordship.
interim order passed at 8
If
Then-
possible lordship, the second week of August lordship.
Why,
Malay as far
19
as-
matter, not 28 matter. 4th of August.
Yes, sir. Interim order continue lordship.
election.
Master.
May beg your lordship. I beg to mention a matter RFA 130/2018. The matter may be listed on 25/7/20
RFP regarding what?
regarding lordship eviction.
You are the plaintiff.
And I'm for the respondent and
In the
appellant is,
suit. In the suit, you are the plaintiff or what?
yes, sir.
You are the plaintiff, suit has been dismissed or what?
Actually, I don't have the brief and new to the
Prepare with the facts at least. What do you want?
the appellant is trying to sell the property, lordship.
No, what do you want now?
Matter may be listed on 25/7.
25th. We'll have it on 28th of July,
Yes, sir.
28th July.
Yes, sir.
May I finish, Your Lordship? My lord, in this case, my lord, the joint application is filed in money exhibition case, my lord. Matter is amicably settled. I have paid the already amount. My lord. The joint application is filed, my lord. But the learned civil judge fixed the date on 19 August, my lord. It was earlier fixed, my lord, the case as my lord. So, my lord, but this listed should be continued, my lord, very urgent manner, my lord. So that maybe I have filed this application, my lord, to hear this matter very urgently, my lord. So maybe
You
tomorrow.
understand the matter is settled.
Matter is settled, but the learned civil judge is not hearing the matter, man. She fixed this matter on the 19th August, my lord.
What is the difficulty? What is the
Difficulty, my lord, I am the headmaster of a school, my lord.
Yes.
The departmental action may be initiated, my lord, already initiated. So that decree should be required, my lord. But learned civil judge did not put up this file, my lord, and fix the date on
19 August?
8 August, my lord.
19 August is not far off.
But there is my very urgency, my lord. That should be hard, my lord. Matter is amicably settled already.
So what will you file now?
I have filed to get an order to direct the learned civil judge to hear the matter very urgently, my lord. Maybe tomorrow, my lord, kindly.
We may not pass that order. We will have your keys, but I don't think we'll pass that order. Tomorrow.
Publish.
May I please, lordship?
So I'm just praying for listing of this matter in the next week. The urgency is that lordship, this particular matter, I filed an application for this additional evidence. Now the suit dismissed, appeal preferred. In the appeal, we have during this time, we have filed an application for additional evidence that was allowed. Then the other side came before this honorable court, and this honorable court again revert this matter before the learned trial court for reconsideration of that particular issue. Now the learned trial court has rejected that petition without taking into account that this particular additional evidence can be taken up at the time of passing of the judgment. But this aspect of the matter has not been taken into account, and accordingly it has been fixed for
You filed what?
additional evidence, lordship.
You filed 4127.
Yes, order
Then?
40 and rule 27, that was initially allowed. So the other side came before this honorable court. So this honorable court has passed an order reverting back to the learned
Okay,
trial
now,
court for,
what have you filed?
now the application is pending before the, now the CRP. Because my application order 40 and rule 27 has been
Okay.
rejected now, without
Okay,
taking into
let us-
account that
When
it
do you
can be
want?
taken at the time of
When do you want?
any day in the next week, lordship, Monday, lordship.
Yes.
Public, lordship.
May I please, your lordship? With the consent of the other side, I beg to mention item number 24, Lordship.
Hmm.
This matter may be adjourned for a week, Lordship. Supply, Lord.
Here for the respondent
Respondent. Lord.
on a prayer made on behalf of the respondent, matter then adjourned to be listed after a week.
Much.
Yeah, please allow. I beg to mention item number 16 and 17 with the
Yes.
consent from the other side.
Hmm.
It may be listed next week,
Here for whom?
on behalf of GN Sahiwala,
For the petition, appellant,
appellant.
on a prayer made on behalf of the appellant, matter is adjourned to be listed after a week. 16-7.
Obliged.
May I please, your lordship. Lordship, I beg for listing of a first appeal, your lordship. Anytime as per the court's convenience, your lordship.
New fresh matter.
Yes, your lordship. No, lordship, it has come earlier, but then time was taken.
No, now it will be listed for what purpose?
For hearing, your lordship.
Hearing, matter of which year?
2017, your lordship.
It's all for orders, they don't fix for hearing. We will tell them in the next week.
Next.
Parties have appeared,
Yes, your lord.
service is complete.
Yes, your lord.
Yes, next witness,
Wednesday?
next witness.
Good.
For orders, don't put for hearing, we fix a date for hearing.
Lordship.
May it please, your lordship. Lordship, I pray for listing of a fresh matter, your lordship. It's an FAO. My injunction was not allowed, ex parte injunction was not allowed before the trial court. And taking advantage of the same, the respondents have been going on forward with the constructions and also involving builders and all. Therefore, suit property is at the risk of being, risk of losing its nature and character. Therefore, I pray that it may be listed on Monday. Deeply obliged, your lordship.
When was the order of rejection?
Order of rejection was on 14th of July, your lordship. May I please, your lordship. We are for listing a MSC appeal, lordship. This matter is not listed from last 1 year, lordship.
Here for the claimant,
Yes, sir.
next week.
May I please, your lordship? I'd like to mention one, item number 14, lordship, with the consent of the other side. Kindly please fix this matter after 2 weeks.
Lordship, I am appealing for the plaintiff. This is a 2001, the suit is from 2001. Second round of litigation in RSA, so a date may be fixed.
Here for the respondent was 1 to 5.
Yes.
A prayer for adjournment has been made on behalf of the appellant. However, considering that the suit
14th,
is of the year
2001,
2001,
second round of
As-
litigation.
as informed by the learned counsel for the respondent numbers 1 to 5, the no adjournment is granted, registry is directed to release this case on,
Any date next week,
tell us the date of your convenience. We'll
next
have
week,
it on,
Lordship, what date?
On 27th,
27 July. Deeply obliged.
Thursday for hearing.
Deeply obliged.
Yes.
And your lordship, I beg to list one RSA number 123 of 2022, your lordship. Kindly list this matter on Monday,
RSA, what is the stage?
your lordship.
What is the stage of the case, the appeal?
It's on order.
Wednesday. Service is complete,
Yes, your lordship.
Wednesday.
Yes, Lord. Lordship, this matter pertains to, my lord, civil bench 2, my lord. My lord, it may be listed in the
Have you seen what is the heading of the case?
top of the list.
So, if there is sufficient, aren't we aware that it's the civil bench 2 matter?
Then, my lord, after some time, my lord, in this case, my
This
lord,
matter has been assigned specially, and you are saying civil bench 2.
my lord, after
You're not
some time,
adjourning this
Mr.
matter.
M.U. Mahmood will argue in this case, my lord.
Call him, call him. It is.
Lordship.
And the affidavit by the advocate has been submitted. Like, it is especially on the incident of 15/7.
Privilege. In which case have you filed the affidavit? Where, there are three transfer petitions.
3 cases.
Why?
Three cases are there, my lord. One is guardianship, other is restitution of conjugal right, and other is.
You are for the
divorce.
wife. You are for the
I
wife.
am for the wife.
One for guardianship.
Yes,
Right? Restitution of conjugal rights.
yes. 61 is,
And the
third one is, and the section 9, section 13 of Hindu Marriage Act for divorce
by him.
by him.
Divorce has been filed by wife.
And 9, restitution they have filed,
Oh,
Restitution we
is
have
by
filed.
him.
yes.
The wife is taking divorce.
Yes,
What are the grounds?
on the ground of cruelty.
Now is, what is your case now?
Yes. So for item number 60. My lord, that guardianship case is brought by the husband.
60 is guardianship.
Yes, it's brought by the husband.
Okay. All these three matters have been analytically heard.
Yes,
Analytically been
yes,
taken up.
yes, it was heard. Now at the stage of argument. So before argument, the date of judgment already been fixed on 24. So that is the apprehension. Then
When is the argument fixed?
argument was fixed on 15/7.
Arguments over.
No, on that day, as the petitioner was not there, so that application was filed for adjournment. And on that day, these words were uttered by the presiding officer. So then this application has been filed.
15/7 was fixed for
And
argument.
on that very day, the judgment date was fixed on 24.
Wife was absent.
Yes, wife was subject.
24/7 fixed
Yes,
for judgment.
for judgment.
Where's the order? Where's the order of 15/7?
Order to start the petition. Order, my lord, order copy is not annexed here. Only the
I have the
dates of
copy. Your Lordship.
order.
I have the copy. Similar order in all three cases.
1121 is the restitution or guardianship.
Lordship, that is the restitution.
1121.
1121.
Eighteen-seven has been fixed for
Argument.
argument.
Lordship,
18/7, what has happened?
it is on a present. Next page, Your Lordship.
What are your grounds for the transfer?
My lord, the apprehension, my lord, two statements are there on para 8.
Of,
8 of my petition, transfer petition,
there are 8 of your.
transfer petition, yes. The petitioner begs to state that apart from the above, during the court proceeding, the learned presiding officer made some unnecessary comment against the petitioner which has no relevancy with the case. Once he told the petitioner that she has failed in her duty as a wife. The petitioner is a private practitioner for which she has to remain outstation for thrice in a week, which ought to have been considered by the learned presiding officer, but the learned presiding officer did not ready to hear anything from the petitioner. When adjournment was sought on 36 for cross of the DW, the petitioner was preoccupied for prior professional commitment. PO has imposed a heavy cost on so and so. That is one. Secondly, the incident of 15-7.
Page,
15-7 is, my lord, paragraph 8.
Paragraph
Paragraph 9. On 14-7 for argument and on that date fixed by learned PO, he was on leave and fixed the case on the next day, that is 15-7.
correct.
On 15-7, the petitioner could not present physically due to her professional commitment outside Guwahati. As such, the adjournment petition was filed on her behalf. Learned PO, while taking the matter on that day, has commented to her counsel that she always in a habit of going outside. Ask your client to go to Brahmaputra to wash hand and to come to court with clean hand. Thereafter, the learned PO told the bench assistant to fix the case for judgment on 24/7 without hearing the petitioner's side. And the circumstances the petitioner apprehends that the learned PO is biased towards her case, she might not get any due justice from the presiding officer of the family court. Now, the thing is that, Your Honor, this presiding officer is going to retire on 31st of this month. It is stated in para 10. So he has that urgency to dispose of the cases.
Person retiring is not required to dispose of cases.
No,
Is not required to dispose of cases during the last part of the tenure.
no, that is not there, my lord. But
Yeah.
the thing is that because of these statements, the petitioner apprehends that they may not get the justice.
Anything
Because
else?
a short dates are fixed in all the other cases. Dates are fixed around 1 month or like 1 month, 1.5 months. But in this particular case, this dates are fixed so shortly. And even on the reasonable ground also, the adjournment was not granted.
Yeah, adjournment was granted.
But next day, when the presiding officer was on leave on 14/7, immediately on 15/7 was fixed for argument. Although on 14/7, all the cases are posted.
15/7, it was fixed on 18/7. 18/7 you were absent, but still then the matter has been fixed for on 24/7 for judgment, on in which case you will be allowed for.
On 18/7 on my file,
Is not.
On 18/7, this transfer petition already been filed.
Your argument is over.
Lordship, yes.
Anything else? My lord, my submission is that, my lord, even if the case may remain there in the court, let the case be, date may be fixed on the next month, my lord. After his retirement, some other officer may come and he may decide it. We do not want any inquiry against the officer with nothing else, only on that apprehension, my lord.
Can
want
you
that-
choose- can you choose a court like this?
My lord,
Can you choose a?
no, I am not choosing it because these statements, my lord, that statement made in the open court. And everybody will feel that he or she may not get any justice. For that apprehension.
Where is the affidavit?
Affidavit is there.
In which case have you filed?
Huh? It is common affidavit is filed in, or separately affidavit is filed,
Can we have a copy?
yes. Nine is better. There are two persons.
Where is the affidavit which has been filed? Call for. Where? Requisition. Select, huh? Item number. Oh, no, separate. Similar, no? You filed yesterday or today?
Yes, yesterday evening.
Give a requisition, I should have given a requisition.
Requisition.
Give a requisition.
Yes, it will be the requisition. Give the affidavit.
Yes.
Lordship. Prior to this transfer petition, there was a revision before this honorable court, preferred by the present respondent. That revision was preferred against the order passed by the family court in the restitution of conjugal rights matters, that is 1121.
You had filed a revision earlier.
Yes, Lordship. In that revision, my learned brother also appeared on behalf of the present petitioner, who was the respondent in that matter.
Why is the revision filed?
Revision was preferred, your lordship, because that proceeding was proceeded ex parte against the present petitioner who was the respondent in that proceeding. Because they defaulted in appearance and he did not file a written statement. In spite of their having
Just a minute. You had filed the revision in connection with the restitution. matter.
restitution matter.
Restitution is your petition.
Yes, Lord.
What had happened there? Why did
In
you?
the picture of what happened, she did not appear.
Okay, then
So did not appear, did not file in WS. We filed when proceeded ex parte, we filed our evidence. Then she came and she filed a petition seeking time and again for filing of WS. That was not filed. Even then, at the later stage when it was filed, court has accepted it without vacating the ex parte order. So that is why, being agreed, the petitioner present respondent preferred a revision. And revision was, it is numbered as 108/2022. That has been disposed of. That has been
no, if it
disposed
was
of,
accepted.
Lordship.
What was your cause of action to come to the court?
lordship, because that order was passed, that WS accepted, WS was accepted without vacating the ex parte order. Without vacating the ex parte order,
Now,
being
what,
agreed.
what did this court say?
Court says no, then I withdraw it. When the matter is family dispute, so I withdraw it. But the honorable court made an observation, and that is why. Regarding short dates, why short date has been given? There is order dated 19/9/2022. Heard Mr. R.K. Bhuiyan, the learned counsel, appearing on behalf of the petitioner. Mr. R.K. Bhuiyan, the learned counsel for the petitioner, submits that taking into account that the matter pertains to a matrimonial dispute, he does not want to press the instant petition. However, he has submitted that he has been a lot of delay in that there has been a lot of delay in the instant proceeding on account of the lapse on the part of the respondent, and as such, the direction may be given to the court below to expeditiously dispose of the said proceedings. I have the
learned counsel for the petitioner. However, none has appeared on behalf of the respondent on call. So my learned brother was appeared in that case. Taking into account of the submission, the instant petition stands dismissed on withdrawal. It is, however, observed that as the matter pertains to the year 2019, and there has been a delay in the said proceeding on account of the respondent, as could be seen even from a perusal of the order dated 23/11/2021, this court observed that the trial court, that is the court of the principal judge family court, it should be one, but it is typed as 3. Kamrup Metro at Guwahati shall make an endeavor to dispose of the said proceeding as expeditiously as possible, preferably within 9 months from the date of appearance of the parties. So the trial court, your lordship, are going to dispose of the matter as per this direction. Now 10 months is running. This was the order. This is the position of the trial court. Now they have alleged before this honorable court, they are not going to give the adjournment. Now, in paragraph 9, the petition, they have conceived this fact. Number 2, from their petition, it reveals in paragraph number 9, the petitioner has stated that on 15/7/2023, paragraph number 9 of the petition, as just already read out by my learned brother, that the petitioner begs to state that on last occasion that the date was fixed on 14/7/2003 for argument, but on that day fixed as learned PO was on leave and fixed the case for next day, that is on 15/7/2003. On 15/7/2023, the petitioner could not present physically due to her professional commitment outside the Guwahati, and as such, an adjournment petition was filed on her behalf, the learned PO, while taking the matter on the commented on such and such way. Now, thereafter, the learned PO told the bench assistant to fix the case of judgment on 24/7/2023 without hearing the petitioner side. So, from the certified copy, it reveals that an adjournment was granted up to 18th. Now, it reveals from their own petition, your lordship. I am coming to paragraph number 7, list of dates. They have given paragraph number 7 in their list of dates has been given to the bottom, your lordship. 15/7/2023. Adjournment was sought by DW, fixing 18/7/23 for argument. If this is the position, how can they make a statement that the learned trial court did not give any adjournment, rather fix the date on 24/7 for argument, for judgment? This is the conduct of the party, your lordship. And so far the statement made, they have ever that such type of comment has been passed by the learned trial court. So this has been informed by my client that on that day he was also present. No such comment has been passed by the learned trial court. But this is the position, your lordship.
18, she was not present.
18, she was not present. In spite of giving, no steps has been taken. All right, this petition has been filed. She could have. No steps has been taken. So that is why that the order has been passed. The petitioner is present, respondent is absent. In spite of she having the knowledge that the adjournment is granted on 18/7, because they are their petition. This is not my petition. Their claim is that no adjournment is given, rather fix the date on 24/7/2023 for argument or for judgment. Is it? It is totally false. This type of conduct, because earlier the Honorable High Court observed that there is a delay on the part of the petitioner or respondent. That is why directed to dispose of the matter within 9 months, preferably within 9 months. Already 10 months has been enough. This is my submission before this Honorable Court. Now the conduct of the parties to be looked into when they are going to blame the learned trial court.
You have not appeared, right?
My lord, 18/7, this transfer petition was filed here.
So you are not required to appear.
On that day, she did not appear.
You are not required to apprise the court that you have
She-
filed an
she-
application.
She thought that when the transfer petition is filed, so need not to appear like that.
You have two issues, two children.
Lordship,
They are presently with whom?
now they are residing with the mother. Now,
How,
we are regularly visiting her house.
how old are they?
One is reading at class 8. And the daughters now, she is in class 6, probably 5 or 6.
Son and daughter.
Son and daughter. Son is elder.
And the son is a special child, my lord.
He's a special, that is why that the custody was sought.
And he is getting treatment.
That is to be considered by the learned trial court. But this is the position so far to children.
I will get to it. Have you been, have with the affidavit copy?
Lordship,
What is your reaction to the principal ground of transfer that they are apprehending in view of the
their
Comment-
first ground
comment-
is regarding giving a short dates. Now my submissions to the
no,
effect
on the comments.
on the comments, my learner, my client informed that on that day he was present. And the other officer also present. No such comment ever been passed by the learned trial court. Because for the purpose of this case, this has been prepared.
My lord, this affidavit is signed by an advocate. An advocate cannot have any personal grudge against an officer, my lord. Had it been only by the petitioner, it could have been a different position. Only
Petitioner was not present at all.
Petitioner was not-
petitioner was not there,
How can she give an affidavit?
because the advocate who went there to file the application, before
We want to have a look at the affidavit.
Lordship, this copy has been given.
No, not the copy. We want to look at the
No, I have not done it.
executed copy.
I have not done it.
We'll pass orders, wait for a while, let the affidavit come.
Lord.
We want to have a look at the affidavit.
Lordship.
All of the block, huh? Mr. Sharma, try to expedite getting of the affidavit. Try to expedite in getting the affidavit. He has given the requisition.
Yes,
Just follow up. Requisition has been sent. It could have given early in the morning. Yes. Sir, Roy, which matter? Four is that
This is an appeal by the railways, Melon. This has been filed on a very limited point, but I'm little bit handicapped, Melon. Today, Melon, misplaced the brief somewhere, Melon. I'm aware of the facts of the case, Melon. Problem is, can it be taken up on Friday or at 2, my lord? I'll
2
go
o'clock, you go by the.
I'll- 2 o'clock, my lord. I'll go through the court records, my
Madam,
lord.
be here at 2 o'clock. Or we can have it tomorrow. Not tomorrow.
Fix matters, my lord. Let it be at 2, my lord.
2
I'll go
o'clock,
through
2
the court
o'clock,
records
2
and.
Have a look at that
Lordship
no.
on tomorrow.
today at 2 o'clock. Not been settled as yet.
Lord, since you will have to decide it on merit now, as to whether contempt has been committed or not. Unfortunately, all attempts have failed. And the order that stands on record as on today is being flouted openly, knowingly, blatantly. No, I think ignoring the consequences in my resolution. It is not that he doesn't understand the consequence of it.
Now, if you remember correctly, in the in-camera proceeding, which we had, this court had the opportunity to interact with the parties. Some explanation was given regarding the parking, isn't it? Parking space.
Yes, yes. Well, that is entry from my land. It goes to the end of his plot. That is a common passage kept by us because I have my land beyond the other end also. That is why,
We remember.
Yes.
Vaguely we remember.
Yes. And it was for parking. Normally, at evening, at night, they used to park their car. Now, he raised an issue. It was continuing with adjustment for more than 20 years.
Now, what has happened to the CRP?
CRP is, when it was disposed of, my lord, in fact,
CRP disposed of.
CRP disposed of with the direction that the interim order that was passed earlier, that is binding, that is there, that will follow, and they will not anyway. Kindly see the order, my lord, it is there.
Lordship will see that page, my lord, 14 of our affidavit, my lord.
Oh.
Affidavit, because this was filed, initially the contempt petition was filed
Actually,
when
page 14.
the CRP was pending. And then it was subsequently finally decided,
Your affidavit.
their affidavit, they have filed it,
Page.
page 14,
14.
Annexure A, page 14,
14,
right,
1/4.
1/4. my lord.
Yes.
And
Final order.
lordship may go
This is the
to
final order.
Yes, final order.
final order. Last para, my lord, 18 page. Page 18, 12, paragraph 12. At this stage, for the aforesaid reasons, this court is not inclined to make any comment regarding the merit of the appellate court order. Let the trial court record the evidence and decide the issue. But it is directed that till this suit, yes, so and so is disposed of, the passage shall be kept free from all obstructions. It is clarified that none of the parties of this case shall park any vehicle in the passage till disposal of the suit.
None of the parties.
None of the parties. An earlier order, lordship may seen in,
Lordship will
My
read para
petition.
11, my lord, then it will be clear.
no, direction is there. That direction will prevail. Lordship will kindly see the interim order initially passed here. Page 30, lordship will find. No, yes, page 30 starts. Lordship got it, my lord, in the contempt petition. That was the initial order passed by this honorable court while entertaining the
The
revision.
injunction is now operating by the trial court, by the appellate court.
Yes.
That was, but then now this order is prevailing, my lord, that should prevail. Here, that page 32, last two lines,
32 of your petition.
yes, my petition.
Yes.
32, my lord, this is the order, last two lines. However, as agreed to by the learned counsel for both the parties, it is provided that there will be no parking of vehicles in the common passage space by either party until further orders. That is the order. That was interim.
Now, where is the violation?
Violation is, my lord,
Where we stated what violation?
our petition we have stated, my lord. Can you see? At paragraph 88, to lordship will see page 6,
Page 3,
yes,
paragraph 8.
8. That the petitioner
begs to state that the opposite parties contemners are willfully and deliberately disobeying the order dated 3/2/2021 of this honorable court in so and so. The petitioners brings on record the photographs showing parking of respondents' contemners vehicles regularly since the date of the order dated so and so passed by the honorable court. That then the 9, that the petitioner begs to submit that the respondent contemners is liable for contempt for the honorable court for willfully
Yes, how,
disobeying.
what is the reply here? How we reply to paragraph? 3?
Their reply is very cryptic, if I may say.
In the affidavit of opposition.
Yes. What is their reply? That is why I say, they know it, but they are, after all, this is an agreed order. They know.
My lord, we will first have to understand that, my lord, what is common passage, my
Common passage is understood by everyone. It doesn't have to be explained. But thing is, how that is being used, put to use, how was it being used?
Let us see the amendment
Yes.
paragraph 10
Paragraph 10
of the affidavit of opposition,
of the
reply
affidavit
to 7 and 8,
in opposition, Lordship will see.
reply to 7 and 8.
Yes. With regard to the statements made in paragraph 7 and 8 of the petition, it stated that the statements made therein concocted, false, and accordingly denied. It is denied that the respondent is parking his vehicles in the common places in violation of this honorable court's order. It may be relevant herein to mention that the respondent's residence is on the backside of the building, and it is not through the common passage that the respondent and can and leave his house. Further, it is only through the common passage that any vehicle, including public utility vehicles like ambulance, fire brigade, septic tank, cleaning trucks, etc., can access the respondent residence. The photographs enclosed as Annexure 8 collectively would go to show that the respondent has parked his car on his plot and not the common passage. Further, the photographs enclosed would also go to show that the respondent has not parked his car on the common passage, neither has he blocked the common passage, as it can be clearly seen the passage is free. It is respectfully submitted herein that there has been no violation of the honorable court's order by the respondent as alleged, and the petitioner has time and again filed frivolous applications with an intention to harass the respondent, for which this honorable court ought to dismiss the instant petition. In this regard, it is submitted that the petitioner herein had filed an application under Order 39, Rule 1 and 2 of the Code of Civil Procedure 1908 in CRP so and so, being IA number so and so, wherein the petitioner had enclosed various photographs alleging that the respondent made various constructions over the common passage and prayed for an injunction. In fact, it was the petitioner who has started raising constructions on the common passage, and this fact was duly brought to the notice of the honorable court by way of an affidavit filed on so and so in the revision petition proceeding. Most surprisingly, on 20/12/2021, that is subsequent to the filing of the additional affidavit, the petitioner withdrew the said injunction application, which clearly goes to show that the petitioner is using the instant proceedings only as a means to harass the respondent contemner. The respondent craves leave of this honorable court to refer and rely upon IA number so and so and the additional affidavit. So, well, there is total denial that it is
Now,
not
let us come to the photograph, Mr.
photographs
At least
Yes.
33 of the
of the
of your
petition,
petition. Of your-
on my petition.
You have given a number of photographs of the common passage.
Yes, this is the common place, living common group
Passes, and this vehicle belongs to the
belongs to him.
Now, he says that it is not in the common passage, it is not causing any obstruction.
No, my lord, it obstructs me because, my lord, what happened? This common passage, he doesn't want that I should park my vehicle there. I have a right over there. I have obeyed the orders of this honorable court that parties shall not park their vehicles there. I am following that order. I am not parking, he is parking. He agreed that he will also not park there. Now he says that this is not the common passage. What is the common passage then? That is
No,
the whole issue. My lord.
Mr. Mohanto, the space where he has parked his vehicle, is it ever used by you to ingress and? egress?
Yes, well, beyond that, in the other corner, the other end, I have my own establishments. I have my, these, washrooms, my, all people, they used to go there. I used to park vehicles.
Beyond
That's
this,
the
beyond this
Yes,
parking?
in the other end. In the other end also. And he wants to obstruct me. He wants to obstruct me. That is why he says that from the point where his house starts, I cannot enter beyond that. Whether it is a common passage, it was not sold to him. That was a common passage kept by us. I kept it because I sold the land to him. It is me who kept this.
Yes, where are you parking the vehicle? Park it outside.
Well, I'll reply back.
No, park it outside. Why do you do?
No. They have not
Bala,
come with a prayer before this honorable court that
That
it
case has
has.
been projected is not the case. I will
Come to-
I'll submit
we'll
my,
come to-
I'll submit my,
Kindly see, Malan.
I'll submit.
Here, they agreed in the first order, as I have placed court has
Yes,
directed, that as agreed by the parties. So he knew what would be the consequence, how it would be construed, because the dispute relates to the entire common passage. The facts are to be decided. Facts are to be decided whether I have my properties there, whether this is a common passage, whether he has been given exclusive right to use to the exclusion of me. Admittedly, this was used for last more than 20 years jointly. I used to park my car, he used to park his car, and whenever occasion arose, if someone wants to go out early, then he was kept there, and one can just remove the other and go. This is how in the flats now, all these multi-story buildings coming up there, which adjustment they are going. Now he is not ready to adjust himself now after so many years. He wants that, no, I cannot at all park my vehicle. Then is it that I have sold the land to him? Absolutely. No, he cannot have this. That's why he has ultimately gone to the court, claiming that his absolute right over that property. That is subject matter to be decided.
but as you have stated or submitted, you are not parking a vehicle in this.
No, I am not giving it outside. Because I have given an assurance before this honorable court, I will not do that. How can I do it? But he is doing it. And he has no remorse for that. He has not come before this honorable court. That is difficult on my part, even to not to park there. Kindly review the order. Kindly amend, kindly modify the order. Nothing. Till today, he is just saying, well, there is no contempt at all. There is no remorse. Kindly see the blatant way of dishonoring the order of this honorable court, that too by a person who claims to have higher education up to, my lord, doctorate degrees. If this is the situation, my lord, that is why I say, my lord, law at certain times has to be harsh. At certain times, the law must assert its authority. Otherwise,
What is the state of this contempt case?
it is hearing, my lord.
Now has contempt proceedings been initiated?
No. No. So, lordship
So,
may,
now it have to initiate contempt proceedings.
exactly, my lord.
Ma'am, let me place it, my lord, then your lordship will take
No,
it forward.
see,
my lord. No, my lord, I'll
we'll
place it.
hear you, we'll hear you. We're just sensitively opening our mind. There is no doubt that this is a common custom. You say that your parking of the vehicle is not causing any obstruction to him. That is not the purpose.
No,
we
no,
are-
common passage, my lord,
Yes.
that's what, my lord, what is common passage, my lord? Lordship, may pay my.
Because, my lord, just a minute, my lord. Here, my respectful submission is, when the persons understand the consequence and makes a commitment before this honorable court, they are bound to obey. They are bound to obey. The Supreme Court has come down very heavily on such persons. I will place an judgment of this honorable Supreme Court, my lord. That is in 2009-16 SCC 126. Naba Narang versus Ramesh Narang.
is that
paragraph 34 to 37. Just 131. 37.
My lord,
Paragraph.
paragraph, kindly come to paragraph 34 first, page 141. Thirty-four, 35, I will place my lord.
Hmm.
In this case, the respondents have deliberately violated the orders of this court dated 12/12/2001 and 8/1/22, 2020-02. Based on the undertaking given by the parties to this court, we have been called upon to decide whether deliberate breach of undertaking can attract Section 2B of the Contempt of Courts Act. Before we examine the issue further, it is imperative to clearly comprehend the expression undertaking with the help of subtle law, which has been crystallized in a large number of cases of this court. Then Black's Law Dictionary 35, my lord. Fifth edition defines undertaking in the following words: a promise, engagement, or stipulation, an agreement.
These are not matters of dispute.
Yes,
Once
then
once
kindly
it
come to-
becomes a part of the court's order, it is binding.
exactly, my lord. Then please come to paragraph 46.
46.
Yes, 46 and 47, 48, I will place it. The respondents place the reliance, lordship got it, my lord?
Yes.
Paragraph 46.
Yes.
The respondents place reliance on Baburam so and so. In this case, admittedly, no application, affidavit, or any undertaking were given by the appellant. Therefore, this case is of no assistance to the so and so. That part, then even the consent order does not incorporate expressly or clearly that any such undertaking had been given either by the appellant or by the lawyer before the court that he would hand over possession if the property to the receiver. In the absence of any express undertaking given by the appellant or any undertaking incorporated in the order impugned, it will be difficult to hold that the appellant willfully disobeyed or committed breach of such an undertaking. The court even in this case observed that in fact the reason why a breach of clear undertaking given to the court amounts to contempt of court is that the contemner, by making a false representation to the court, obtains a benefit for himself, and if he fails to honor the undertaking, he plays a serious fraud on the court itself, and thereby obstructs the course of justice and brings into disrepute the judicial institution. The crucial analysis of the decided cases of this court clearly lays to the conclusion that willful breach of an undertaking given to the court amounts to contempt of court under Section 2B of the Act. So therefore, my lord, it has gone further to say, kindly come to, my lord, paragraph 50. Paragraph 50.
Yes.
From the middle, my lord, the respondents were, the line begins.
Yes.
The respondents were in fact successful in keeping the petitioner totally out of the management and control of the company. This situation carried on for years together. This was absolutely contrary to the letter and spirit of the undertaking given by the parties to this court. The order dated so and so and so and so are based on the undertaking given by the parties. The respondents blatantly and deliberately violated the orders of this court based on the undertaking given to the court. Consequently, the respondents are guilty of deliberately flouting and disagreeing, disregarding the undertaking given to this court. In order to maintain sanctity of the orders of the highest court of the country, it has become imperative that those who are guilty of deliberately disregarding the orders of the court in a clandestine manner should be appropriately punished. The majesty of the court and the rule of law can never be maintained unless this court ensures meticulous compliance with its orders. Then kindly come to 53, my lord. Consequently, we convict the respondent under Section 2B of the Contempt of Courts Act and sentence him to simple imprisonment for a period of 2 months. We further impose a fine of ₹2,000 to be deposited by each of them within 1 week, failing which they shall further undergo imprisonment for 1 month. 54. We are also not oblivious of the fact that immediately sending the respondents to jail would create total chaos in the company, which would also vitally affect the interest of the large number of people, including the employees of the company. Therefore, while keeping in view the peculiar facts and circumstances of this case, the sentence of imprisonment imposed on the respondent is kept in abeyance. We further direct the parties to meticulously comply with the undertaking given by them to this court. In case similar violations of the undertakings given to this court is brought to the notice of the court, in that event, the respondent shall be sent to jail forthwith to serve out the sentence imposed in this case. So this is how the honorable court, apex court, my lord, dealt with the situation. When the undertaking was flouted. And then lordship may also kindly come to 2008-14 SCC 115. Here also it is willful disobedience.
2008.
14 SCC
115.
115, Anil Kumar Sahi and another versus Ram Sevak Yadav and others. Here, paragraph 50, I will refer to. Yeah, so next. Yeah. 2009. 2008, do you know? 135. Huh? Page number 135. 135. Page, no? No, oh, 2018. 88 pages, yeah. Right. Yes. 135. At page 135, Lordship will find paragraph 50.
Yes, we have read.
Lordship.
We have read.
Yes. It is by now well settled under the Act and under Article 129 of the Constitution of India that if it is alleged before this court that a person has willfully violated its order, it can invoke its jurisdiction under the Act to inquire whether the allegations is true or not, and if found to be true, it can punish the offenders for having committed civil contempt, and if need be, can pass consequential orders for enforcement of execution of the order, as the case may be, for violation of which the proceedings for contempt was initiated. In other words, while exercising its power under the Act, it is not open to the court to pass an order which will materially add to or alter the order of alleged disobedience of which contempt jurisdiction was invoked. When the court directs the authority to consider a matter in accordance with law, it means that the matter should be considered to the best of understanding by the authority, and therefore a mere error of judgment with regard to legal position cannot constitute contempt of court. There is no willful disobedience if best efforts are made to comply with the order. Here it is not the case, my lord. Even there is no attempt, rather he is sticking to the point that no, I have not done any contempt. I am doing what is being done, right, from before, even after the commitment given to the honorable court. So I cannot
It should
commit
not be a
any crime.
deliberate.
It
It
is
should
a,
not be deliberate and willful.
my lord, it is a deliberate in my
No,
respect.
it should not be deliberate and willful.
Yeah, exactly, exactly.
If it is deliberate and willful, then there is no
Then,
escape.
my lord, that he cannot escape the clutches of law. None cannot. That is why, my lord, the apex court has said, and kindly also, now kindly see, there is no even remoteness expressed remotely. Never says, even knowingly or unknowingly, I have not committed contempt, or there may be any. There is no apology. Nothing has come forth from the respondent. Contempt now. Nothing.
Is it?
And blatantly he is saying, rather he is finding fault. He is finding fault that, well, there is no,
Is there any counter allegation made that you are also parking the car?
no, nothing, nothing. He cannot say that because I am not doing it since the order was passed. I am not doing it. And the contempt was filed long back. Till today, he has not come up. If he has faced certain difficulties, certain otherwise obstructions, that or he has no alternative just to park it, then he ought to have come and made an application for
Right.
seeking review.
Right.
Nothing was there. And simply says, no, I have not committed contempt. That is why, my lord, my responsible submission is that there is no any ground now to consider it plain and clear. So going by the attitude, the approach of the contemner,
Okay.
my responsible submission is that this cannot be, and he deserves to be taken into task under the appropriate law. Contempt should be drawn up and he should be awarded appropriate punishment so that the majesty of law prevails.
Is this all right?
Lordship will see the order as matter. 3/2/21,
Page
page 31.
31.
31. Before that, my lord, I will factually describe about the place matter. Two friends purchase a property. The front side, one friend, like Mr. Tudi,
Mr. Roy may not be very interested in the fact.
then I.
We are only on the violation part.
Okay, my lordship may see the order, my lord. Third, Mr. Lordship, K.K. Mahanto, learned senior counsel, assessor by K.K. Mahanto, A.K. Mahanto, learned counsel appearing for the applicant. Also heard Mr. D. Barwa, learned counsel, assisted by Mr. A. Ali, so and so. This IA has been filed by applicant, that is, my lord, Mr. Tudi, seeking certain clarification in order dated 9/11/20. Now, 9/11/20, my lord, that order is not been annexed, my lord. Passed by the court in so and so, according to Mr. Monto, the disputed passage is a common passage. Now, that's what matter. I initially submitted the common passage. One has to understand that what is common passage. Meant for use applicant as well as opposite party for the projecting and erroneous interpretation of order dated 9/11/20. The opposite party is obstructing the applicant from parking his vehicle while enjoying the said passage for parking of his own vehicle. Mr. Barwa, however, strongly repeated the arguments and submit that it is the applicant who is deliberately obstructing the passage to be used by the opposite party. After hearing the submissions advanced by the learned counsel for the parties, this court is convinced that the dispute between the applicant and the opposite party relates to usage of a common passage. It appears that based on a mutual consent, the arrangement using of a common passage peacefully has continued about past 22 years, that is until present dispute has cropped up. So and so on the one application has been filed before the court on the same projecting the different dimension of the dispute. Since the applicant and the opposite party are neighbors and they are living in adjacent building inside the common campus, I am of the view that the proper course of action in this case would be expedite the possibility of a negotiated settlement of the dispute through mediation. Since both Mr. Monta and learned senior counsel and applicant Mr. Boba, learned counsel appearing for the opposite party has submitted. In one was that their respective clients are willing to appear before the Guwahati High Court Mediation Center with the view to settle the dispute amicably, and the matter is being hereby referred to the Mediation Center, Guwahati High Court. Then the mediation manner, then the matter was listed for 6 weeks immediately after receiving the report of the mediation center. However, as regard to by the
As agreed.
counsel for the both the parties.
As agreed, not regard. As agreed.
As agreed.
However, as agreed to by the learned counsel for both the parties, it is provided there will be no parking of vehicle in common passage space of either party until further. This is the order, madam. Now, Lordship, I initially read that applicant seeking certain clarification order dated 9/11/20. I've given that order 9/11/20. Heard Mr. So-and-so, madam, then second parameter, by filing this IA, the applicant seeking extension of the interim order dated 14/6/2019 passed by this court in CRP number so-and-so with a further clarification that both parties be permitted to use the common passage causing hindrance obstruction to each other. It appears that order dated 14/6/19 passed in so-and-so court while issuing notice to the matter had passed an interim order suspending the operation of the order dated 26/4/19 passed by the learned court below by further directing that petitioner applicant would not pose any obstruction in the free unhindered passage of the disputed passage. Mr. Mohta submits that due to an unintentional error and oversight, there was a representation on behalf of the petitioner when the matter was taken up by this court on 33/10/19, as a result of which the interim order got vacated and default, hence the prayer. Responding to the submission made by the applicant, counsel Mr. D. Borwa submits that he would not have no objection if the earlier interim order is restored. But insofar as the prayer or usage of common passage is concerned, the applicant cannot be allowed to park his vehicle in the aforesaid passage, since such a measure would block the entire entrance of his client. Mr. Borwa further submits that applicant has adequate parking space in his campus for as many as 2 vehicles, and therefore there was no necessity to block the passage. It appears that the applicant and the respondent are neighbors and the community residing in the said plot of land, and the disputed passage Schedule B. Now here is a catch, my lord. Schedule B, it has been mentioned here, and I will say subsequent to what happened. Schedule B of the plane is the only access to the respondent to his plot of land. Having regard to the circumstances case entirety, I am inclined to extend the interim order dated 14/6/19 passed by this court, so and so. Order according. Insofar as the prayer made by the applicant to allow him to park his vehicle in common passage, then again Schedule B of the plane, that is common passage described in Schedule B of the plane, without causing any disturbance to the respondent is concerned. This court is of the view that unless mutually agreed terms and conditions are evolved by then between the parties permitting the usage of passage without posing obstruction to each other, any order of the court such during the pendency of the suit would uncalled for. Therefore, without making any comment of the aforesaid order.
Mr. Roy, this order ultimately has merged into.
No, I'm coming, man. I'm coming to that.
Modification order.
That Schedule B, lordship, the common passage.
Yes.
Now, my lord, I've given that order 2010/2011, my lord. As you got, lordship got it.
Yes.
Then 2011, what happened, my lord? The opposite party that my client has filed a petition to rectify. This is very important. But Mr. So applicant and so IA has been filed with prayer to correct the typographical error in order dated 9/11/20 passed by this court in civil 1173 of 2020, whereby the common passage involved in this proceeding has been erroneously described as Schedule B. According to Mr. So Schedule B ought to have been Schedule B. The opposite partner has, however, filed an objection on 9/11/20, opposing the prayer for correction of the error interiorly countering that the expression Schedule D ought to not to be included in the order dated 9/11/20. Although the affidavit of opposition filed by 19/11/20 is not on record, yet a copy of the same has been handed over to the court by the learned senior counsel appearing for opposite party. I have perused the same. After perusal of the objection filed by the opposite party, it appears that the opposite party is raising question as to the manner in which description of the property has been furnished with regard to Schedule D. In this case, the dispute is
It should
evidently
be
with
D
regard
instead of B.
B.
Yes, then
Schedule D is the common passage.
D is the common passage.
D is the common passage. Well, that has been clarified.
No, what is the consequence then?
Because I'm coming to that, man. Lordship will just bear in mind. In this case, the dispute evidently regard to.
No, we have
common-
read this.
Read this. Okay, man. Now, my lord, Schedule D, now lordship will come to my suit. This Schedule D is from the suit.
Yes.
Lordship will see Schedule D, my lord. Schedule A is the entire land of the parties, my lord. Schedule B is the land of Mr. BP Todi, my lord. And Schedule C is the land of Natrola. This is my client, my lord. And Schedule D is the common passage. This is, my lord, 10 feet to 61 feet is the front portion, my lord. My client's property is after 61 feet, my lord. That is not the common passage. In fact, I found the sale and purchase of the agreement. I show, my lord, the entire that passage is there. It has been sold to my client. And the injunction order, my lord, if your lordship see the injunction order. Contemplation, lordship. Now, injunction order, lordship, the see page 23 of the contempt petition, my lord.
Yes.
23 and lordship come to page 25. The operative portion of the order.
Yes, 25.
Accordingly, the order has it got dated 24/9/2005 passed by the London Municipal Number Mijay case number 22120 is set aside and the appeal is allowed and the respondent, his men, agents, workmen, associates are injected from blocking the common passage. Common passage there's no schedule D and also from parking any sort of vehicle or from storing of any object over the common passage as per schedule D. The respondent is also injected mandatorily to remove the iron shed with the plastic of the roof erected over the common passage and also remove the small garden used for planting of flowers on common passage. This is the common passage, my lord. Now we filed, my lord, for violation of the order in the trial court. They have violated the order. A strip has been drawn up, my lord, where your lordship gets the commission may be appointed and see that what has been done. The road has been narrowed down to 7 feet. This is what happening, my lord. Common passage is not the entire space up to the my place that we go to whatever we feel like. His space is out.
No, Mr. Mahanta is saying that he has got certain property.
No, nothing, my lord. Listen, show from the records, my lord. What?
Some washrooms or something.
No, my lord. Yet entire property belongs to the petitioner, my lord. There was some understanding. They are good friends, so they are using it. That's a different thing, but not otherwise. That's why the court said we cannot do anything. You go to, and then this is also, my lord, the contempt. My additional affidavit, the order, my lord, the final order. Lordship may see, my lord. Lordship come to page 18, my lord.
How?
My additional affidavit.
In this proceeding?
Yes, that final order in this
Yes.
CRP, my lord,
Page-
189.
page-
Page, my lord, it starts from page 14, my lord, and 18 is the. I'm not troubling your lordship to read the entire order, my lord.
Additional affidavit.
Affidavit. No, my reply, my lord. This is my reply, that is my affidavit in opposition filed by on behalf of respondent.
Your reply in contempt case.
Yes. Affidavit in opposition, my lord. Page 14.
Oh, you're not your reply, your affidavit of opposition.
Yes, affidavit.
Okay, which page?
Page, my lord, 14, my lord.
Yes, 14 you have got.
Starts, my lord, page 17, lordship may see.
Yes.
Para 10, my lord.
Hmm.
There is no doubt that 10 feet wide passage is a common passage for both sides. The passage came into existence on the basis of agreement between the parties. Therefore, both sides are not entitled to change the size and nature of the passage.
Hmm.
For holding this view, the no special knowledge of law is required. Then lordship may see para 11.
Yes. Yes, we have seen.
No, lordship,
read this.
last sentence, lordship may read, if the allegation of the respondent are accepted at in its face value, this court shall have to hold that petitioner has blocked the passage, thereby causing inconvenience to the respondent. It is not me blocking, it's him blocking the passage.
That is the allegation.
Then, my lord,
But are you
lordship,
alleging that he is parking his vehicle on the passage?
no, after this order, he's not parking. He has enough space front 2 vehicles he can park.
No.
I have given the space.
No, without going into the intricacies, why don't you park your vehicle outside?
Well, what's in the room, my lord?
Huh?
When I have a common passages,
He's parking in the road.
No, common passage is up to his, that end of the road.
He's parking on the road, isn't he?
No, he's not parking, he's parking inside the house.
Yeah.
Because he is a space. My space has given allotted to the last end of the, because that is my property. And up to 61 feet from the road is the common passage. That's the schedule D of the suit.
Your
Right.
plot starts after 61 feet.
After 61 feet. Your lordship, that photographs I have,
Where have you stated?
no, that is from the plane itself, my lord.
Print is not discernible. From the schedule, it's not discernible.
Yes, I
Schedule
will,
does not give the length and breadth.
in the meantime, lordship may see the photographs I placed it earlier during the.
Mr. Roy, file an affidavit. File an affidavit saying that the common passage which has been described in Schedule D, that is not disputed. Now, Schedule D, common passage is not disputed.
No.
Schedule D says that it is 9 feet by 61 feet.
Yes.
He says that 61 feet is up to the entire thing, and here it is. His persons are using some properties beyond that part. You file an affidavit.
I file an affidavit. And rather, my lord, if your lordship see the agreement and the schedule,
No,
it
we
is,
have seen the schedule.
yes,
What is, the problem is that from the schedule, it's not discernible.
My lord,
There are 4 schedules.
one thing more, my lord.
Yes.
Here, probably my learned friend is not properly instructed regarding facts. Here, kindly come to, my lord, the Pixar will show page 16 of my petition. I have given the drawings when the site plan was prepared. Where is my petition?
1/6.
1/6. Annex 2. This is the site plan prepared by the GMD authority which passed. Here it shows.
Yes.
My lord, this is the site plan. First part, this first at the bottom, this is the building, proposed building. This is my building. Second is his building.
Hmm.
My lord,
Hmm.
right hand side lordship has seen
Common passage.
the common passage leading to up to at last lordship is septic tank at the towards the upper part.
Yes.
Septic tank is there.
Yes.
This road from my area last to the last, this is kept as a common passage.
What is the distance?
Distance is 10 feet by one.
How do you get? The length?
130, 138 feet. 138 feet. This is the length. He wants to claim that I have no access beyond, my lord, that his portion starts beyond my portion. He wants to block me there. And he says, you cannot go beyond that. This is not, that is why when he,
Schedule D,
Schedule D, he describes up to this portion. I have filed a counterclaim. That no, he has manipulated things. My claim remains up to the end of his plot. My
what
property
is
is there.
your counterclaim?
Counterclaim, those are there, my lord. We will place it, my lord. Today I am not having it. Counterclaim and all that is there. It was filed.
Have you questioned the Schedule D also?
Yes, that is a wrong description given. That is, hold this, that is why common passage court didn't say anything else. This honorable court says only common passage. Common passage, can you see the next page, my lord? Next page will be more clear at page 17.
The type,
This
fair copy.
fair copy,
fair
yes,
copy, yes.
yes. Existing building, my lord, it is by first part is mine, existing building of Dr. Tudi. This is written there. Then next is existing building of Mr. Agarwal, Natural Agarwal. Common staircase is there for us. Then this is the road it takes, my lord. Kindly see. Up beyond this septic tank, toilet, security room, this is there, my lord. At the top, my lord. This is my property. So I have left this passage open to go there.
This septic tank, security room, these are common properties. I think.
No, this is mine. His property comes there only, close that, my lord.
Show from the
Yes.
event, my lord.
This is there. This is the site plan.
No, site plan also contains his building.
Yes, his
And,
building.
there it also marks the top portion as septic tank, toilet, security room.
Security room. This is mine. This is what he never claims that this is mine. He says now he has nothing there. This is what he is now saying that he has nothing there. Well, what about this? I have been using I've been using all this. I cannot go now. He keeps the vehicle there. He entirely blocks the passage there.
This 25 feet by 10.7 feet is your property.
Yes.
Huh?
It's a-
Yes, it is my property.
That septic tank
Yes,
25
yes,
feet
yes.
by 10.7 feet.
Exactly, exactly. But this is my property. That is why I said this is a common passage. How can you get it? I never gave it to you. I have kept extra land to be used as a passage, common passage.
Your lordship,
To
have
go
to see
there.
the sale agreement.
Now,
Where you stated this thing? This is a very important aspect. That you have property beyond.
those
the
are,
building.
those are stated in the counterclaim, WS, all those are stated there.
Do you have a copy?
Today I do not have, but I'll place it.
I think that will be very relevant.
Yes, yes.
If on record you have stated that you have properties beyond the building of the
Exactly,
respondent,
exactly, exactly,
then the meaning of common passage may be different.
exactly. That is what I'm claiming.
And we would also be interested to know whether you have disputed Schedule D.
Yes,
His contention is that Schedule D is the common passage up to 61 feet,
exactly,
and thereafter it's not there.
not there.
If you are disputing, then the matter would
Exactly.
have a different connotation.
That is a dispute lies there. What is the common passage up to which extent? I claim that this is up to the end of his plot. I have my property beyond that. And this is I have shown. He
Sir, I
says
have
no.
got properties beyond your building.
No, my lord. Lordship see the sale
No, this
agreement. my
septic
lord.
tank,
I,
and-
from page 9, to the contempt petition, lordship will see.
no, come to page 70, the drawing, 16, 17.
No, this is not the septic, is not them, theirs, my lord. And that's what I'm saying,
And this
that
property is whose?
my property, my lord, every lordship will see the sale agreement, deed of sale, my lord, 9, page number 9. This has been sold to me,
Is 9.
9. Nowhere it's been mentioned that the properties, that beyond that the properties,
Let us see the description.
yes, this deed of sale is made on this
The
day,
description,
yes, 1 katha 10 lachas, my lord,
description.
a description. Now, before that matter, lordship may come to page 14.
Just a minute, description, schedule,
No, lordship will come to 14, my lord. For a moment, one paragraph I want to show, my lord. Page 14, my lord,
14 where is it?
of the sale deed.
Yes.
On the top, the seller and the purchaser shall jointly use the common passage.
Which is west?
Page 14, my lord.
One second.
Kuntu paisa?
Which is west?
No, kuntu.
Oh, the-
Not on the east.
In my contempt.
my lord, west is, my lord, I will show, my lord, west is, my lord, the main road, my lord. In this 17, my lord, map,
This
west
back-
is the main
back-
road.
Backside is east or backside?
Backside is, my lord,
East.
east, my lord.
Is there is a pakka wall of
Yes.
land belonging to Singh and Burman?
Yes, Singh and Burman. I'll show you, my then south lordship may see the land of
Sultan.
Sultan Ali, south. South is on the right side, my lord. Lordship is the land of Sultan Ali. And then north, my lord, lordship is the land of Jayanta Sharma.
Jayakanta Sharma.
This doesn't belong to him, my lord.
No, we are interested in the east.
East is Singh, my lord.
East, south is rather.
South is Singh.
South is-
Jayakanta Sharma, the south is, my lord, land of Sultan Ali. East is, my lord,
East is
Pakka boundary wall of land belong to Mr. Singh and Mr. Burman. This is east, my lord. On the backside, my lord.
At best, it can be southeast and in both sides you.
No,
don't
it's
have
not
land.
there, my lord.
My lord, kindly see what is the area shown. Here specific, the area of land measuring 61 feet into
see-
32 feet.
Presently sitting here, we cannot know what is the area.
Exactly,
But we can certainly know what is the boundary.
yes.
Now the boundary is not matching what you are contending.
No, boundary is beyond that, because within that I have property. We must
You
have
have not
mentioned,
stated.
That
my
is,
lord, boundary,
In the schedule, you have not stated. Then on
boundary,
the east side, you have your own plot of land, a small plot.
Pakka boundary
7 by
wall
10.
of land belonging to Mr. Singh and Mr. Bowman.
Burman.
Burman.
This is the outer boundary of the plot. Outer boundary, within that, if I have my properties, that is shown in the site plan, which was approved.
No, no, no.
And the land sold is only 32 feet, 61 feet into 32 feet. Your measured area was told. Total measured area was told, specific.
Then in that case, you should have stated in the schedule that on the east side, you have.
I have my also properties that would have been mentioned.
No, no, that is not there, it is your sale deed.
Well, true, that was not mentioned, but that doesn't exclude my properties
No.
if within the outer
We
boundary I
can
have.
only
my-
go by the documents. You may be correct in contending that
Yes.
actually the situation is different. But the sale deed says that on the west,
It is not
on
mentioned.
on the
True,
south and east.
true, my lord, that is
the
not
only,
mentioned.
Only.
Because this is an agreement, this is common passage is an agreement between the both of them that we have kept it.
And Lordship,
This common passage is there. It is not that common passage has not been mentioned. Common passage is mentioned.
sale deed page number
And
14
common
may be
passage
seen.
leads us to the end
Page
of the
14.
plot.
14, my lord, may be seen, my lord, sale deed.
Hmm.
The seller, I'm reading it, my lord. The seller and the purchaser shall jointly use the common passage
Yes,
measuring 10 feet approx on the southern side of the land, beginning from the main road leading to the plot of conveyed to the purchaser. That is up to that plot. It can't be extended to that portion. And 10 feet now been reduced to 7 feet, my lord. There's a violation
No,
itself, my lord.
that is also again not correct, because that is to be decided. Now, my lord, so far the land is sold 30,
10
2
feet has
feet
been reduced to
into-
7 feet, my lord. Even a car
No,
cannot
no,
go,
Mr. Roy, 10, whether reduced to 7, perhaps
my lord.
this court may not be in a position to go into that aspect.
exactly.
But you may be correct in contending that in first paragraph of page 14, the land conveyed to the petitioner, to
Yes.
the purchaser.
Yes,
The common passage is only up to the land conveyed to the purchaser,
yes.
Not
But
beyond
up to
that.
that portion, my lord.
not beyond that.
Not beyond that, my lord.
My lord, this is, if I may explain, my lord, he has been given a specific area. Till that, he has a passage. Till then, beyond that 61 feet by 32 feet, if there is some more land,
No, no, from where do you make the submission? Where is the material to?
that
Develop-
those are the materials pleaded before the court below in those WS and
I
under the
think,
contract claim,
I think you come up with.
That
You did not file it, but at least bring it,
at least to show before your law.
present it before the
That
court.
can
And the
be clear.
schedule of the land will
That will-
prove it, my lord. Schedule of the land is very clear, my lord.
Initially we thought different, but
And then, my lord,
there is
entire
some
matter
more
has been.
complications.
My lord, that is why I am saying, my lord. If they want to twist the whole thing, that is, they want to deny my right over the extended portion. That is why the whole dispute is, I am raising, that is why this honorable court, when we prayed for the modification of the order, clarification of the order, that schedule B and all that was not mentioned. Court said the common passage. Common passage is a disputed passage. They say it is up to his land, not beyond that.
No, the sale deed is not disputed.
Sale deed is not disputed, but there, my lord,
Sale deed
there,
is not disputed, your building permission is not disputed.
my lord, yes. Therefore, this shows that there is a passage, there is a land extending beyond.
Definitely, there is a plot of land where, a piece of land rather, where there is a septic tank,
Yes,
security room.
yes.
But that land, whether it belongs to you, there is no materials.
My lord,
There is no materials in the
Well,
on record to
so
come
far
to that
that-
conclusion.
that boundary is concerned. Lordship may consider one thing more. I have given him the land within my campus, within my boundary. My outer boundary is Mr. Singh and Bowman. My outer boundary is Mr.
Your
Singh and Bowman.
submission,
Within that,
unfortunately, your submission is not, is commensurate, is not coinciding with the schedule of the plane.
well, but that is what I'm saying. The schedule of the plane
And ask not to the schedule of the.
of the cell deed,
Cell
yes.
deed.
That is
Cell
why
deed.
here only the outer boundary of my land was mentioned. This is my land, I have given to him. My land, out of my land, this area,
No, no, the
61 feet, 32 feet.
Schedule
is-
is of the area which you have sold to
Handed over
him.
to me, madam.
Schedule is not of the area which you belong, which you possess or you own.
But if I may understand it properly, I would like to convey to your lordship. I have sold a portion. This is my land.
See, Mr. Before you answer, this sale deed does not have two schedules. That schedule A is the
Yes.
owner, is the owner's property, and
Yes.
out of that, B has been carved out and B is within A. It is not like that. That has got only one schedule, which has got a boundary on the east to be Pakka wall of Singh and Burman.
Yes,
And
yes.
Pakka wall of Singh and Burman is the end of the land boundary wall.
Well, true, my lord, that is what I am saying.
You bring those, I think, statement.
It
and
will be
whatever
more
is there.
clear from those, I think, my lord, that will be more clear from the statements made before the trial court. Lordship will find how this was, my lord, the outer boundary must be mentioned. If within that I have properties that will remain to me unless it is given specifically to me.
Outer boundary of only the land conveyed, not the land you are owning.
My lord, the land
The
conveyed.
land which is the subject matter of
True,
sale, that boundary is of this, that schedule.
My lord, kindly see that was told that
We
septic
cannot
tank and
know that there are
security,
two boundaries, three
No.
boundaries.
this septic tank and security, this is in the other side. His land goes to that, but it is this other side, this remains in my common places. Therefore, my lord, this is the common places list, here is my property. His property is up to this.
Okay, you bring your.
So let us, yes, my lord, I will place it, lordship will consider.
Will
They want to now restrict me up to this land, not beyond that. This is the dispute. But if measurement shows that I have kept,
But Mr. Mohanta, tell us one thing practically. What difficulties are you facing? Apart from the your allegation of violation of the coast order.
my lord, my difficulty is now I have not been able to park my car within my place also.
No, that is the undertaking given by the court, given to the court.
Yes,
By
I-
his parking in his area, let us assume.
I cannot go to my last portion, that
Why do you
septic
need to
tank,
go?
all that is, he covers the
Why do you
entire,
need to go?
because I have to go, my security people, my outer, my lord, all the helping hands, they used to go there.
They cannot go by the passage.
They cannot, they cannot, they keep the cars in such a way that it's difficult to pass through. That is what my instruction. They want to claim that no, you have no access beyond this. That is the difficulty. And who will always, my lord, every morning,
You park your vehicle in your own, inside your own building. There may be some people going, they can go on foot, they are not going to pay any vehicle.
I am not using, I do not take my vehicles to that part.
You cannot, you will not, there is no
I'm not.
question.
I'm not.
You say that your man would go to that area.
Yes,
What
man,
is the-
my
where is the
chauffeurs-
obstruction?
my socketers,
Where is the obstruction? Even if a vehicle is being parked.
even, my lord, that if there is park, this space is such, they park in such a way that nobody can pass to the next place. That is the difficulty. That is the difficulty. Because they
What
want
vehicle
to,
do we have? Bus or what? Lorry,
Myself,
yes,
a small two cars, my lord,
small car.
small cars.
oh, cars are there, which covers the entire 10 feet.
My
area.
lord, the actual problem started,
A small Mercedes.
small car. Lordship see the passage, it's hardly 7 feet vehicle, a car can pass through. That's why, my lord, we filed a violation in the trial court. And they filed a counter claim, and we filed a violation petition, my lord. It's going in the trial court. Let me, the entire matter be relegated to the trial court, my lord. The trial court will see what is the violation, my lord.
I think this matter should be transferred from this court to some other high court. Let them face the burden. Why are you burdening us? And that too, an advocate is involved.
Exactly, my lord, this is, that is why I say, my lord, it has to see the light of the day in some form or other.
Okay, we'll have it next Tuesday or next Wednesday.
Lordship may fix it. Wouldn't it? Not Tuesday. This way on
The
Wednesday.
documents are otherwise ready with you.
Lordship.
The document, the written statement, other places.
Those are there in file, my lord. Those are there. We'll get it.
Get a
Because
copy,
trial court lawyer is there, we will have to have it.
Get a copy and place it. for the
Yes.
When lordship wants to keep it.
court. Tell us.
Kundi number, 20 kiman tarik,
Affidavit prohibited. I said. Huh?
26.
Huh?
Well, Thursday, 26.
Not 26th, 25th.
Huh?
25th, my lord.
Or speaking
25th of Digday हुए हैं, बहुत में था.
Senate council, Senate council for the petitioner. Whereas
26th,
here, and
26th,
Senate council has appeared for respondent. Sarah,
25th of November.
this court is of the opinion that certain materials which are part of the proceedings in the lower court are to be placed on record as agreed to by the parties, list for orders on
25th.
25th, okay?
25th, my lord, I have matters, but then.
Tell us an agreed date.
My lord, on 28th also, if
Then
possible,
on second, my lord,
or on
2nd August.
2nd August,
2nd August, okay,
2nd of August.
yes.
I think you can take this back and give it at the time of,
The photographs I've given, maybe keep the record.
no, you please it. But to just check whose dog papers, there are 2 citations also. Cultural paper. Now this should not be a dispute, who has submitted what paper. That's okay, take a second.
কিবা দিছিল নেকি? আমিতো দিয়া নাই। আমিতো দিয়া নাই।
There are 2 citations.
Citation third day.
Yes, you can take it, you can.
What was taken note of?
We have taken note, we will place it again.
Okay.
2009-15 is the
Offline.
176.
And regarding that High Court case which they have mentioned, the order was passed in some High Court, the civil division matter.
Yes.
That was only in respect of this section 9 petition, that is their applications for restitution of conjugal right, not in all the cases. And there was no any direction for taking up all the cases analogously. No order was passed like that.
Uh, 108 was only with respect to the restitution matter.
Yes.
108 lordship, there is a guardian custody matter.
One
JRP 108.
Sure, it is a restitution matter.
Restitution. is-
Restitution matter. No, sir.
Are you on caveat? No.
Lordship,
Are you on caveat?
in this case, no, I know.
I heard. Sri J. Sharma, Senate Counsel for the petitioner. Also heard Sri R. K. Bhiya, Senate Counsel for the respondent. The present 3 applications have been filed under section 24 of the Code of Civil Procedure for transfer of 3 cases pending in the court of the principal judge, learned principal judge, family court number 1,
One lordship.
Kamrup, within bracket M, Guwahati. The petitioner herein, the petitioner herein is the wife of the respondent husband. Sarah. While transfer petition 60 of 2023 relates to Miss within bracket G case number 184 of 2019 pertaining to guardianship filed by the husband while transfer petition number 60. Husband along with transfer petition number. What is 61 is
Six-one relating to the divorce matter.
and restitution
Restitution is 62.
and while transfer petition number 62 pertains to FC civil number 1121 of 2019 pertaining to a petition filed by the husband for restitution of conjugal rights. Full stop. The third case being transfer petition number 61 of 2023 pertains to FC civil number 407 2022, which has arisen from a petition filed by the petitioner wife under section 13 of the Hindu Marriage Act for divorce. Full stop. Para. The primary apprehension, primary ground of filing these transfer petitions is on the apprehension of bias towards the petitioner by the learned court below. Full stop. To demonstrate such apprehension, comma, the Sri Sharma, the learned counsel for the petitioner, has drawn the attention of this court to the averment made in paragraph 8 and 9 of the petition. Full stop. In paragraph 8, comma, the learned counsel, now it has been stated that some unnecessary comments were made to the extent that when an application for adjournment was submitted by the petitioner on 15/7/2023 for adjournment, comma, a comment was made to her counsel that within inverted comma, she always in a habit of going outside. Full stop. Yes, take it. Is 7 inverted comma. Huh? It is further submitted that on 15/7/2023, comma, a prayer for adjournment was made by the petitioner wife, and the matter was thereafter fixed on 18/7/2023. Full stop. On 18/7/2023. However, Sri Sharma, however, submits that since these petitions were filed on 18/7/2023, comma, his client or her advocate did not appear before the learned court. Full stop. Sri Sharma has also raised the issue that very short dates are being fixed in this case, unlike other cases, which raises some suspicion on the conduct of the learned presiding officer. Full stop. It has also been stated that the presiding officer would be retiring on 31/7/2020, and therefore undue haste has been shown in this case. Full stop. Para. Sri Sharma accordingly submits that an order be passed transferring the matters to any other competent court, to any other court of competent jurisdiction, or in the alternative, to pass an order referring the matters to a date after 31/7/2023, when the matter can be taken up by the successor in the office of the presiding officer. Full stop. Para. Per contra, Sri Bhuya, the learned counsel for the respondent husband, has submitted that the facts projected are not at all correct. Full stop. If by refuting dealing with the grounds which have been projected in support of the transfer petitions, Sri Bhuya submits that the grounds are absolutely frivolous and mere figments of imagination, and he disputes that any comments, any unnecessary comments were made by the presiding officer during the proceedings. Full stop. He submits that to the contrary, the petitioner has been negligent in defending, in attending, in conducting the cases, as a result of which the cases are pending for a long period of time. Full stop. The learned counsel has also, based on record regarding an order passed by this court dated 19/9/2022 in CRP within bracket IO 108 of 2022, which had to be instituted by the petitioner as petitioner under peculiar circumstances, when the wife was allowed to contest the case without vacating an ex parte order. He submits that though the aforesaid CRP was withdrawn, certain very important observations, certain observations were made by this court which are relevant in the adjudication of the present. Full stop. Para. This court, in the state order dated 19/9/2022, has made the following observation. Sri Bhuya, according to submit, that in view of such observation, that the proceedings are to be taken up expeditiously as possible, and preferably within 9 months, was the consideration which stayed into the mind of the learned court, and therefore dates were fixed. Full stop. He submits that even the deadline has not been able to be met, and therefore the next date has been fixed on 24/7/2020 for judgment as admittedly on 18/7/2023, the petitioner wife chose not to appear before this court, and no steps were also taken informing the learned court regarding filing of the present matter or to seek adjournment. Full stop. The Bhuya, by referring to the order dated 15/7/2023, which has been put on record, which has been placed before this court, has submitted that the state order would reflect that the petitioner wife was seeking adjournment in spite of the fact that sufficient time was already granted to present their arguments. Full stop. The court accordingly had fixed the next date as 18/7/2020 for argument in presence of the petitioner, in spite of which she has chosen not to appear on the state date, that is 18/7. The learned counsel for the respondent accordingly submit that there are no grounds for entertaining these petitions, and therefore the same are to be rejected. Full stop, sir. The Sri Sharma, in his rejoinder, has however submitted that the aforesaid CRP IO 108 of 2022 was pertaining to only one case, namely the application for restitution of conjugal rights, and therefore the state order would not be applicable to would not have a general applicability. He has further submitted that there was no order of this court for having an analogous hearing. Full stop, sir. The rival submissions made by the learned counsel for the parties have been duly considered at the material stage before this court, including the orders of the learned presiding officer and the order dated 19/9/2022 of this court have been duly considered. This court has noticed that the principal contention and ground for seeking the transfer is on the allegation of bias, as certain within inverted comma unnecessary comments inverted comma close were alleged to be made by the learned presiding officer. Full stop. Incidentally, however, the state comments have been alleged to have been made in presence of the counsel for the petitioner, whereas the averments have been verified in the affidavit by the petitioner as being true to her knowledge. Full stop. There is no doubt an improvement on the side of the petitioner by filing an additional affidavit by her counsel, by Sri Subham Medi, who has stated to be the counsel of the petitioner. Whereby the same statement has been made and the same has been verified to be true to his knowledge. However, the affidavit has not even remotely stated that the particular advocate Don't pray like that. Sarah. The proceedings are continuing since the year
2019.
2019. And in the meantime, 4 years have passed and the matter is at the stage of final argument. Full stop. There is no explanation on record as to why the petitioner chose not to appear on the date fixed for argument dated 18/7/2020, and therefore this court is not inclined to attribute any fault on the part of the presiding officer for passing the order dated 18/7/2023, fixing the date for judgment as 24/7/2020. Full stop. This court has also failed, this court has also is also not inclined to accept the grounds projected to be sufficient ground for seeking a transfer of these cases. Full stop. The allegation of bias is a matter of perception which has to be substantiated by materials on record which are found lacking in this case. Full stop. Para. In view of the above, this court is of the opinion that no case for transfer has been made out, and accordingly, the petitions are dismissed. Full stop. However, in the interest of justice, this court would request the learned would make a request to the learned principal judge, Family Court number 1, Kamrup, to allow the petitioner wife to place her argument on 24/7/2020 before passing of the judgment, which may be deferred by a couple of days to the convenience of the learned court.
Good.
We have to place have this on record.
Lordship.
Do you have copies of this?
Lordship.
Good day.
In.
Please, your lordship.
Yes.
On earlier occasion, we are allowed to take such steps by paper publication upon respondent number 5 and 6, which we have taken, and it was kept at flag Y, my lord.
You filed the affidavit.
My lord.
MS M. Musahari, Learned Counsel.
S. Musahari, my lord.
So, yes, sir. Last time it was written M. Musahari, right?
My lord, wrongly written, my lord.
MS S. Musahari, Learned Counsel, appearing for the appellant, has submitted that pursuant to the order dated 1/6/2020, notices upon the respondent numbers 5 and 6 were to be served by means of paper publication. And in compliance with the said order, such publication has been made in the edition of the Assam Tribune and the Osomia Protein dated 15/6/2020 Full stop. The same publication since original have been put on record by way of an affidavit dated 26 June 2020. Full stop. Sarah, the service is according to be complete. Full stop. Elsewhere is not. Sarah, since Elsewhere has already been received, comma, the matter, the appeal may be listed for hearing in due course.
Must oblige.
May I express lordship? Actually, this contempt of case is arising out of RS 32, 2023, and I filed along with the IA lordship. So the time in the meantime, the 10/3 of the 2020, 10/3 of 2023, the Honorable Court the first and status quo for maintain the status quo to the board party. Then the time lordship, after the first order, I mean, the respondents.
You have
tried
alleged
to-
that there has been violation of the order of 10/3.
Yes.
You alleged that there has been violation and you have filed this contempt petition.
There
Are you
was-
alleging violation of the court's order
Yeah, lordship.
and therefore you have filed this contempt petition?
Yeah.
Have you
lordship.
filed your affidavit?
Yes, we have filed the affidavit and police report what in compliance with in response to their petition, a police report was called for. That is on record.
Earlier, Domino was not made party.
Right.
But in order dated 21/4/2023,
Hmm.
the honorable court has was a direction was given to me, lordship, to collect the police report regarding this matter.
Hmm.
Accordingly, I have collected the police report.
Right.
It is on record, lordship.
Yes.
It is on record, lordship. As per this police report, no construction is going on in the place of occurrence, lordship.
Lordship, see, 6. IA 6, I mean. 621.
Hmm.
The respondent petition, respondent the affidavit already emitted lordship. Actually, he see the 621, I mean, for the respondent, the affidavit lordship. See the paragraph 3.
Paragraph?
Paragraph 3. That with regard the statements made and paragraph. Paragraph 4. Paragraph. Yes, paragraph. Paragraph 3, we have proceed. The make so the respondent stated that the appellate the court party allows so and so. The plaintiff could not to prove that the respondent had encroached the suit land so and so as the right around to the appeal the party given
What
to.
what is your name, Mr. Counsel? Are you
Yes.
Rongmai?
Yes,
Mr. Rongmai, there is a report from the concerned police station whereby a physical inspection was made and no constructions were found. If you want to have a look at the report, you can have a look at the report.
yeah, I seen Roto.
You have
But
seen.
if the law agency is not, I mean, cooperate, then honorable court is also difficult to take.
Report has been furnished by the concerned police station. So there is nothing to disbelieve this report. It
What-
says that there is no construction over the plot of land in question.
Proceed, what I means that the report is given to, negative, but his affidavit was filed in IA. He he removed the house and such, and so everything is stated in the IA.
What is
I
the
mean-
restraint? What is the interim order?
Interim order is both the party,
To
Lordship,
maintain,
to maintain the
Status quo.
status quo.
now we have seen that there is no construction over there.
In and further order, but
You take instructions from your client. In view of this report, we may like to close this contempt.
right.
Give a copy. Do you have a copy of this? Copy of the report? You have? 26/2023. What is a copy to the Bennett colleague?
I got that.
You take instructions from your client.
Yes.
In view of this report, we would not like, have you taken instructions?
No.
Take instruction. Are you a house station council?
Yes.
Where do you come from?
From Dimapur.
You tell us a date of your convenience, we'll take it up whenever you. You take instructions from your client on the report. You will fix the date as per your convenience.
So kindly fix another.
Will tell us the date of your convenience. You are an occupation council, whenever you.
In the month of August.
You tell us a date, whenever is convenient for you.
Yeah.
Tell us.
Yes.
Then give the-
So the second August. Really better.
2nd August is okay. Third. We are a wrong mind. Then a council for the petitioner. Third. Tell him file. Tell him if he's consenting.
It's okay, third is.
Third Thursday, not Thursday, we are not fixed. Fourth.
Fourth is okay.
Land council for the petition. Also are three MP Sharma. Also are three PR Gogoi, government advocate. As well as three MP Sharma for respondent.
Respondent.
One sole respondent. Three Gogoi, the Learned Government Council has submitted that do the government of staff is not a party command. He was directed to obtain a report after a physical verification of the area in question. Full stop, para. He submits that person to such directed, comma. A report has been furnished by communication dated 20/6/2023 by the officer by the senior, by the concerned officer of Patkoti Police Station, Karbi Anglong District. As per which, on inquiry, it was found that no construction was going on in the disputed land. And photographs have also been included. In the fitness of this, this court directs furnishing of a report, furnishing a copy of the report to the learned counsel for the petitioner to seek instruction. As requested, list on 4th of August. 4th August.
Proceed is concerned, my lord, that is the injunction, my lord, petition.
Which one? We are only on the contempt petition.
Seven, my lord.
7 is has come along with 7. We are not passing any order.
My lord, seven, actually, my lord, there is no, my seven, I have objection, my lord. Because, my lord, in the suit itself, there is no prayer for recovery of land.
Position.
My lord, that is the vital point, my lord. For that,
No, has the RSA been admitted? No, it's not been admitted.
my lord,
Has the RSA?
arrest not admitted, my lord, not yet.
If not for admission.
No, arrest only the emitter or six. Okay, then there is the sixth issue, the 4 issues have been rejected by, title is belong to me.
RSA has been admitted.
Admitted, my lord. Let me I have submitted my.
It is admitted unless the LCR comes for,
Yes.
you
For
will not take up an
For that,
LCR.
it is still has to project title is,
That is
you know,
already there.
I am maintaining status.
That is already there.
Yes, I am maintaining
That is
status.
another report. From the prime, from the report,
That will be a
from the
hearing
report, it
number.
primes the appears that the allegation of contempt may not be substantiated. Absolutely, however, independent of the, however,
Much.
Your Lordship, we have already taken steps through paper publication and
you
we,
filed the paper application on, filed it.
the affidavit is left out, Your Lordship, so we are filing the affidavit by today.
Your name
Ms. Nazima Dakhar. And Dakhar.
and car. Council appearing for the applicant submit that pursuant to the order date 17/5/2023, step for service of notice upon the response number 1 has been taken by paper publication.
Sure.
Full stop. He however submits that the affidavit could not be filed in the meantime and therefore prays for some time to file the affidavit to bring on record the aforesaid paper publication. Full stop. Para. After 2 weeks time,
Within 2 days or 3 days, Your Lordship will
Ah.
be filing the affidavit.
he however submits that the affidavit, he however submits that he however submits that the affidavit required to be filed to bring on record the state publication could not be filed in the meantime, which however shall be done shortly. Full stop. Para. Please after a week to enable filing of such affidavit.
Much obliged, ma'am.
May I please, Your Lordship, I am respondent. This is the electrification date. Date is occurred in the year 2000. Now it is 2023. In this regard, High Court has passed order 24/1/2020. Early disposal of the case, but till now, DJ's family have not get any compensation.
Like 32,000 has been granted.
50,000 for stay of this matter only.
32,000 has been granted by the trial court.
4,000, yeah.
32,000.
Yes, Your
Only
Lordship.
50,000 has been given to you.
Only 50,000.
Where is the ACB?
They never appeared. One is
Last
filed by the
occasion-
private parties, 1 to 4, and 5 to 7 at the electricity board.
Last occasion they had appeared. Mr. Bhattacharya was there. We'll have this at 2 o'clock. We'll dispose this of. We may dismiss the effect for the fall. You inform the ACB, okay? At 2 o'clock. 2 o'clock today. Railway appeal.
Not-
Yes.
MF,
You're praying for enhancement or what?
no,
What was that?
MFM.
Understood. Against the railway.
RCC.
Against the dismissal order of railway claims tribunal.
Oh, it was dismissed.
Uh, This,
Tell us.
this MFA was filed against the order dated 22/11/2017.
Let us read the order.
Or- Order is annexed. Mm, Page number, annexer 7, page number 33.
33.
Yes.
Yes, please.
In this case, two main issues were framed on the basis of the pleadings, whether the victim was a bona fide passenger or whether the victim died in an untoward incident. Here, the issue number 2, whether the victim died in an untoward incident, it is admitted. It is admitted, and in page number 36, decide positively in para 2. But the issue number 1, the victim was a bona fide passenger or not. In the original application, we have already filed all the documents where your lordship kindly see
Why was it dismissed?
the question arises on his bona fideness, whether he purchasing a ticket or not. We have filed the police report with the original application. Kindly see page number 29, annexer 6.
Yes.
It was also exhibited in this police report. Kindly see the paragraph number 2 and
On receipt of this memo. Paragraph 2, on receipt of this memo.
no, a second paragraph. Second paragraph, line number 1 to last paragraph, during inquest over the dead body. During inquest over the dead body, one general railway journey ticket bearing number 92167376 dated 21/2013 from Badarpur to Hojai was found in the back pocket of the wearing pant of deceased, which was seized accordingly as per seizure list. The IO has given this report at the time of during the time of inquiry. But later on, when the DRM is submitted before the court by the respondent, there is no mention about the seizure list, and LCR is in the DRM is in the LCR. They produce the ticket where the same IO, Satyendra Som, wrote some lines in the ticket that the above railway journey ticket bearing ticket number 92167376 dated 21/2013 handover by Mohammad Fariz Ali, relative of the Tayyibur Rahman on 24/2/2013. But he has given this police report on March 18, 2013. If we rely on the police report, the police report is given the applicant on 18/3/2013, and according to him, ticket was handed over by one for Fariz Ali on 24/2/13, and he did not made any seizure list in this case. And we filed this police report with the original application, but after 1 year, DRM has filed a report before the RCP. They also did not inquire about this police report. And tribunal called 3 times the IO, but he did not come. Only this, on the basis of this point, the case has been dismissed. And
Yes, what do you say, Mr.?
Your Lordship, the judgment passed by the bench on 2211. Lordship, please go to the paragraph number 5, issue number 1.
Now, how do you deal with this contention that during the inquest, one railway ticket was found from the back pocket of the deceased, bearing a particular number and date? If that is the fact in the inquest report, can you ignore the claim?
There is a 2 statement passed by the investigating officer. One passed on, if your Lordship go to the paragraph 11 portion at 7, the judgment which has been passed by this trial court, it has been mentioned here, Lordship, that the ticket has been received after more than 1 month, not in a conscious position of the bona fide passenger at a given point of time. There is a police day case report where it says that in that 11 point of time, there is a mere single word about the ticket, the bag, which is stay in the back side. There is no mention.
So what about the inquest report?
Inquest report, it says there is no any mention about those things.
Let us see the inquest report.
Annexure 4, page number 21.
There is no mention.
There is no mention about the ticket.
In the inquest report, there is no mention.
No mention. So these things, the contradiction of the 2 statements by the investigating officer cannot be done. Either have to be done.
If his statement is corroborated by the inquest report itself, that during the inquest it was found, then the matter would have been different. But if the inquest report does not say anything about recovery of a ticket, then his statement made later on perhaps will not make any improvement in the case of the.
Improvement of the case. That's the point. What my submission is that, Lordship, for the
This is
case of the interest of this case here, Lordship. So for the dependence of the claim of this case also, in the issue number 4 and 5, there is no any mention about the whether she is the bona fide legal wife of the deceased
No,
person.
we have
So my
submitted the
humble
next
submi-
of kin certificate.
That things I have seen in her custody right now, but that things have not been exhibited in the court. So my humble submission is that if it is genuine, let them give again remand back to the trial court. Let me decide whether that certificate, the ticket which have been found is is a duplicate one, Your Lordship. It is a Xerox one. It is been mentioned in the court.
No, also.
Let me see. Whatever it is in there, it is in the Xerox copy, Your Lordship. Assuming a person have been dead in that 11 point of time, that ought to be have there. There is no any question of giving a third party, Your Lordship. It is happened here in this case,
In
and
the-
this thing have been beautifully narrated by the trial court in the paragraph 4.
We'll take it up.
In DRM, they also produce the Xerox of the ticket. In DRM also, they are.
At 2 o'clock,
That is.
after the.
I am deeply obliged. You will see in the paragraph 6, 7 and 8
Of
the judgment passed by the trial court.
Yes.
Paragraph page 3, page 3 of the judgment. I have the record here. It is issue number 1.
Just a minute.
Page 3.
Yeah.
Photo of the-
Yes, there's number 3 to 36. 36.
Page 36. Correct.
Does it is 22nd of November,
Lord,
22nd November.
yes, Lord, that does that.
Yes. Page,
Page 3, relevant portion at issue number 1, that is page 3, the last portion in the paragraph 5, last portion. Doing enquiry. On sub-para is there, your lordship. May I read, your lordship?
page 3.
Page 3 of the judgment. Paragraph 5, last portion, your lordship.
During inquiry.
During enquiry, EO has collected all the requisite particulars from the concerned GPR, GRP office and SS office. Further, in the letter of CCM, FM code, so and so on the date of the incident, it is mentioned that 21/2003 from all the record, it is established that the incident of so and so was took place on 21/1/2003. Further, it could not be ascertained whether the person was bona fide passenger or not, since in the report of GRP, it is not mentioned anywhere regarding the recovery of the railway journey ticket from the victim. And therefore, thereafter the consequence effect upon the paragraph 6, 7, 8, your lordship, where it has been categorically mentioned about the Caesar list, inquest report, GRP report, nowhere mentioned that the ticket.
Read.
If you lordship permit me, paragraph 6 also.
Yes.
On close scrutiny of the documents placed on record, lot of doubtful facts have come to his notice of this court regarding genuineness of the ticket. Photocopy is placed on record as Exhibit D, your lordship. Below this photocopy of ticket, it is written and signed by the in charge Lanka GRP office that the said railway journey ticket, hearing ticket number so and so, dated on 21/2003, handed over by the so and so related to the issues on 24/2/2003. The incident took place on 21/1/2013, 20th of midnight, after more than 1 month. Then paragraph 7, your lordship. It is relevant to mention here that as per claim petition, the victim was traveling from Badapur to Kujai by down Nagaland Express 21/2003 and fell down from the victim at Lanka, train at Lanka station, your lordship. Then next page, your lordship. He died on 21/1/2003. The aforesaid so and so had made a statement before the insert so and so camp FRB hospital that on getting the information of the accident of the victim, he along with Muhammad so and so maternal uncle of the victim went to the FRO hospital, where they meet the victim lying on the ambulance on examination. Doctor declared him dead. The claimant had failed to show any why the said so and so did not hand over the said ticket to the in charge of Lanka GRP on the same day. It is also not explained to us to how that ticket came to his possession, which he handed over the police after a lapse of more than 1 month. So that's the point, your lordship. On the same day, if the inquest report also forwarded with the documents, whatever is statement by the Faris Ali before the IO, then also it can be accepted. The ticket which have been received after the more than lapse of 1 month, the relevant section of the passenger also does not fulfill that criteria. Now, thereafter,
Read it.
yes, the result of the case that shows that the victim of the
Body of
the case also so the body of the victim was identified, said Faris Ali. There is also mention of examining this person as witnessed by the police along with the Abdul Rahman. No Caesar is placed on record to prove that something including ticket was recovered from the person of the victim. Therefore, it is not understood as to how the ticket came into the possession of Faris Ali. He also signed an inquest report. Please note, your lordship, on 21/1/2003, but not mention about the ticket to the police. He also deposed his witness, your lordship. The case diary seems to have been closed on 31/8/2013 by giving final report that the deceased died due to fallen down as run over by running train due to his own fault of the deceased, and there is no fault playing behind the death of the deceased persons. Said final report was signed by Dharani Gayan, SI Landing GRP. He was cross-examined as R1. He deposed that he has not investigated the matter on the spot, but he has only signed the final report after going through its contents. He has admitted this fact that in this report there is no mention of Caesar list or handing over the ticket by Muhammad Faris Ali. Therefore, it is not understood as to how said ASI Satyendra Som separately written report on 18/3/2013 and mentioning about the handing over of my ticket by the said Muhammad Faris Ali. He has mentioned in his report, contrary to the case diary and other documents on record, that during inquest about a dead body, one railway journey ticket being so and so dated on 21/2003 13 was found in the back pocket of the wearing pant
Dr. Gogoi, is the degree of proof is like a criminal case, is it beyond all reasonable doubt?
Yes, Lordship. Because you-
Here, in a railway tribunal, beneficial case of legislation, the degree of proof is beyond, is preponderance of probabilities.
But-
There is one statement, there are contradictions, no doubt, but it is not a case that ticket was not there at all. There was a ticket.
issue remains is that ticket, whether in that relevant point of time, the application of the Faris Ali, he had given in inquest report in that relevant point of time. He never uttered a single word.
Is it your case that the ticket was not of that date?
That is the part, your lordship, we want to verify the original ticket was not been exhibited. It is a Xerox copy.
The police has said that while giving, it was given on such and such and signed by the police person.
The police has mentioned yourself, but thing is demanded that already the Caesar list case diary, the statement by the later part of the
There is no
investigating
Caesar
officer is contrary to the investigating officer, your lordship. One person can give the 2 points. One, there is no ticket. Another point says is the back side of the deceased person, it is a ticket. Now, assuming your lordship, there is a 2 points, Caesar list and case diary. Or in the examination of the witness, never mention a single utter word about the recovery of the ticket, your lordship. That relevant point of time. Mere statement given by the investigating officer cannot fulfill the criteria, your lordship. Then procedure of the investigation.
That is the question which you are trying to pose. That while ascertaining compensation, what is the degree you are doing? Will you apply a very strict procedure? Or will you be satisfied that there is substantial compliance?
So lordship, another point is that so far the dependency is concerned, that is also question doubtful.
I have filed the next.
We will come back.
In the issue number 3 and 4, your lordship.
You take your statement. We'll come back.
Yeah, if you lordship permit me, if you lordship permit the paragraph 10,
Yes.
I read it for this honorable court under 9 itself.
9. Okay.
Yes, sir. It is also not understand why the applicant was not informed by the Faris Ali about the incident by the police as stated by her cross-examination. Though said Faris Ali was related with the victim and also made a statement before the police. He identified the body of the victim and also signed the inquest report. That means Faris Ali, your lordship, but remains silent about the ticket for such long time. There is no mention about the ticket statement on 31/1/2003. These facts also creates doubt in mind of the court that since the distance of the place of occurrence and the residence of Faris Ali seems to be quite long, how he reached the place of occurrence so soon to identify the body and signing the inquest report. The logic has been given, your lordship. Therefore, recovery below the ticket is
These are
found.
all presumption, Mr. Gupert. Persons, he may be residing in a long trip, but at that time he might be there. These cannot be the sole determining factors. That how
Lots-
he could be there. He could have been there.
There are lots of possibilities here. If the ticket isn't being a specific a person name, then it is a okay, your lordship. But it is general ticket. There is no name. In assuming at that point of time, your lordship, I along with my other friends also went there and I collect the friend from my that ticket. That also can be presumed in that manner also.
After 1.
And later on, your lordship, issue number 3 and 4. I leave it to the these things before this honorable court regarding the ticket. Application has not placed on record by document to prove her relation with the victim except voter ID card. But neither death certificate is placed on record nor legal hair certificate issued by the competent authority is filed. Therefore, it is held that application failed to prove her relationship with the victim. Issue number 3 and 4. Your
Yes. Who is the applicant?
That's the point.
Who are you?
Rahela Begum.
No. You don't know the
And
name.
I'm
Why?
How are you connected with the deceased? What is your relationship?
wife.
Why? He hasn't deposed before the tribunal. Dr. Gogoi,
Lordship,
she has not deposed.
Yes,
she
she
has deposed.
Then what else do you require?
Lordship,
I did not cross-examine her that you are not the wife.
we had cross-examined her. And
In a case of this nature, are you questioning the relationship? Yes, you can, if you have doubt. No, mere deposition is not, this open for cross-examination. If a stranger would have come, you'd have been exposed. Over and above, she has the voter ID card. What else do you need?
That part is there, Your Lordship, that I cannot deny that. But the only issue remains is that, Your Lordship, if
The
the
approach appears to be hyper-technical in a claim petition like this. How much is the amount otherwise admissible in a railway claim?
4 lakhs is there, and but my humble submission is that, Your Lordship, it is a case like this way. There's thousands of life flying from one place to another. It became a precedence to everyone.
Tribunal is there to decide what precedent. They had a ticket, it was proved that he died in a motor railway accident is not disputed. Only thing is that whether he was a bona fide passenger. That is the only thing. It is upon their burden. Now this burden appears to have been discharged. Let us see the evidence.
Evidence on affidavit by. Huh? You have not done it. He has not deposited the evidence.
It is the LCR.
LCA is there. It is there, Your Lordship. In her statement, she said that I'm the wife.
What is that? How many months?
Even in the statement of Faris Ali also, Your Lordship. No mention. Recovery of the ticket. Nangmani Mandal also said same.
Nagmani Mandal.
He said that fall down from the express, Your Lordship.
Yes. And what is the occupation of Nagmani Mandal?
Statement of ASM. Assistant station master. Lonka.
He says that he had fallen down from the Round Express in process of retraining. Hands and legs were cut.
These things are also there in the police report as well as in the report. But the issue remains is whether in that even point of time, due to heavy rush in that point of time, Your Lordship, it occurred. If Lordship go to the next, Abdul Rahman also, no mention of the recovery of the ticket. Even in the affidavit filed by the Rehana Begum also, he also mentioned about the inquest report. in the exhibit B, your lordship. But in inquest report, after perusing it, there has been no mention after a single word about the recovery of the ticket. Generally, your lordship, in the postmortem report, whenever we go, your lordship, the inquest report is the first, then thereafter it goes to the postmortem report for doctor, medical opinion. But ultimate, in that relevant point of time, inquest report, if it is there also, the seizing officer will definitely pick up the case. If there is any ticket in the backside of the deceased person.
Colony carry on.
Your lordship,
Yes.
I exhibited the ticket. It may be on LCR. Ticket is certified by the GRPS, Lanka, where there is no any statement written there. Later on, how that statement can go? Exhibit D
Perfect.
in LCR. His signature is there.
There's 3 unmarried daughters.
Yes, no, and they are getting married now.
No, at the time of the
Yes.
death.
No, exhibit করেছে, that is certified for-
Exhibit 1. There is a statement by in the police report. The police report has been exhibited as Exhibit A. During inquest, awarded airport one general railway journey ticket bearing numbers 2 and 2 found in the back pocket of the wearing pen.
This statement have been done, Your Lordship, after a separate order. That has been reflected in the order, City, Your Lordship.
But this is the police report.
Police report. It has been mentioned, but that is the question asked by the trial court. That therefore, it is not understood how sent ASI Satyam Sundar separately written a police report on 18/3/2023.
Exhibit B, sir. We wanted to have a look at the inquest report. It's not there. PM is here, inquest is not there. So, Google, can you have a look at?
My Lordship has pointed out what probably the move would be, sir.
I have not found the inquest report. Is it there?
Lordship, if, first of all, if I go to her statement, Your Lordship, I have not the eyewitness of this case.
Yes.
I have not seen my husband purchasing the ticket and boarding the state train, that is Nagaland Express.
He was not there. This is what, how is it relevant? Is she claiming that she was there?
Police report, sir. Inquest report form is there.
Inquest is there.
79. There is no mention of the ticket, Your Lordship, only the in this part.
There's
It's a case 79. Paragraph 12 of the inquest report, in the opinion also, there is a mention about the injury party. Inquest report was done on 21/1/2013 at 11 AM. That is there.
Yes. Yes, madam, what about the case law? What is how is a tribunal supposed to decide a claim petition?
There is a point, your lordship, in the judgment copy, paragraph 6, page number 36.
Just a- 36.
Yes, 36.
Yes.
On close scrutiny of documents placed on record, lot of doubtful facts have come to the notice of the court regarding genuineness of the ticket. Photocopy is placed on record as exhibit D. Below this photocopy of ticket, it is written and signed by in charge Lanka GRP police that the said railway journey ticket bearing number 92167276 dated so and so handed over by Muhammad Farid Ali, relative of the deceased Toibur Rahman, 24/2/2003. Your lordship, kindly see in the affidavit in evidence, I exhibited this certified copy of ticket, which is signed by this police officer. And at that time, there is no not in below the ticket. In affidavit in evidence, with affidavit in evidence, I exhibited this ticket, which is certified by that IO. There is no note there. How it just came later on, that note? Because we have filed it.
Which note?
In DRM report, last, the ticket is submitted last.
Page.
DRM. In DRM. There is no page number in DRM.
Is it a part of the case? LPR?
Yes, this is mentioned in the judgment copy.
Which
the ticket in the DRM report where he note this.
Where in
statement.
the judgment? Which part?
Paragraph 6, page number 34,
Hmm.
36. Page number 36, paragraph 6.
Yes. Where is the mention to DRM?
In the last page of DRM. Ticket is there.
No, where is the mention made in the judgment?
Page number 36,
Yes,
paragraph
paragraph
6.
6 we have read. Photocopy is placed on record as exhibit D. Below the photocopy, it is written and signed by in charge
In charge long.
Longta. So what is your submission here?
My submission is he mentioned the date 24 to 2013, but he certified the ticket where the date is on March 2013. And at that time, there is no note below the ticket. I exhibit this with the affidavit in evidence.
Where is it? Where do you?
It is in LCR. LCR, affidavit in evidence of Rahena Begum, exhibit D.
This has got the signature of in charge Lanka, CRP, 30-23.
Now, this is the IO of Lanka.
That is in charge of Lanka
Sorry,
GRP,
yes,
23.
he certified the ticket on March 2013, and he said that 24 to 13, Faris Ali handed over him the ticket. Then where is the note at that time?
What does Faris say?
There is
Where is Faris?
no, there is no statement of Faris that he had
No,
handed
but
over the
is Faris a witness?
witness. No, he only identified the body.
Faris was not a witness.
No, he is not a witness.
Who's the witness? Only you,
Yes,
sole witness.
yes.
Lordship, with your permission, Your Lordship. The separate report was submitted on paragraph 8 in 18/3/2013. I have just now crossed over it. 18/3/2013, there's a separate or written police report by Satyendra Som. The executive was done on 23/2013.
3.
18/3/2013 is the report, and exhibit of that ticket was on 23/2013, Your Lordship. That is the left.
No, we
Report
applied.
has been filed earlier before, and exhibit comes later on. Your Lordship.
No,
That is there shown in the certificate copy of the order.
exhibit.
18/3.
We exhibited all the documents at a time, but his signature on the certificate to be true copy on 23/3, and he said that Faris Ali handed over the ticket on 24/2. Then where the note below the ticket? At that time, March,
Yes,
and we applied for the documents.
Your Lordship, report has submitted on 18/3/2013. Thereafter, there is nothing left beyond.
18?
18/3/2013. 18/3/2013, Your Lordship, the report has been submitted by the investigating officer. And the ticket was exhibited on 23/2013, Your Lordship. That is the case
No,
in the
no,
record in here.
Not exhibited. He
Whatever is
signed,
there, certificate to be true copy, Your Lordship.
certi-
It is available on record, whatever.
we
my department has
exhibited, we exhibited at the time of evidence, but he gave the ticket on 23/3/2013.
Mr. Go, there are two, this is very easy to be explained. He gives a police report. On the date of the police report, it is not required to give them a certified copy of the ticket. They collected the certified copy of the ticket on 23/13.
But that should be narrated, Your Lordship, that I had seized the matter and I have certified on that. Everything should be clear.
No, 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 police report has got nothing to do with giving them a certified copy of the ticket.
That is the report, Your Lordship. The court observed that there are two separate sheets, sir. Two separate order sheets by the police report. One at a file at Your Lordship on 31/8/2013 and another as a 18/3/2013 as per paragraph of the statement of the 8.
No, no, either of the report, that has got no connection with the certified copy of.
No connection, sir. This is
A ticket which was in their possession. They can give a certified copy at any point of time.
any point of.
And he has given on 23/3/13.
The inquest report, the Fariz Ali, if you Lordship go to the inquest report, Your Lordship, and that 11 time also he was there and he will put his signature. And he is the person who give the ticket to the wife or the investigating officer. That will even point of time, if you see the order sheets of the note sheets of the inquest report in details also, you will find at that 11 time, he identified the dead body.
No, inquest report, you are correct that it does not speak anything about any ticket. At the time of inquest, there is no mention about any ticket recovered. You are correct that way.
There are lots of possibilities are there, Your Lordship. After having this, and I do not want to attack because since it is a case of defined manner, because I am also grateful condolence. But so far that this tank of this case is that, Your Lordship. Mere showing of the ticket, otherwise this Railway Act doesn't fulfill the criteria, Your Lordship. Where is the definition says 229? Where is the passenger ticket?
We will go by the records unless you allege any fraud or any other misrepresentation by them. We'll go what is there on record.
My humble submission is that
You may be correct that to just to have the claim, some tickets of somebody else was procured, that can be done. But we cannot presume that. Unless you raise a serious question, no, this is not the ticket of.
the available on record which is mentioned in the paragraph 6, 7, 8, 8. That is my answer before this honorable court, Your Lordship. Whatever the learned trial court has passed. That there is nothing infirmity on that part.
In the main claim,
That is my humble submission.
the annexure 10, page number 44, the next of kin certificate is filed before the tribunal. I have annexure.
We are not on that. We are not doubting your relationship with the decision. We are only on the claim, merits of the claim.
Now my submission is that police has given his own report that he found the ticket back pocket of the deceased person, and later on he has contradicted his statement.
Police said deposed.
No, the 3 times we called him, but he did not come. Tribunal called him, he did not come.
He was called.
Called.
He was summoned on 3 occasions.
Yes, he received the notice also. Record has been there.
Since the Your Lordship, evidentiary value of that document has not been proved, the investigating officer never came as per the statement by her.
No,
So there's no
record
issue.
is there.
Whatever the statement, if he prove-
Respondent called him.
if the statement
Respondent
says that,
copy.
yes, I have certified copy, I have got the document, I have got the receipt, the ticket
So
copy,
this
I
is-
am the person exhibited that this one, so and so.
This is the point.
Exhibit C is there. The ticket has been exhibited.
Exhibit was dictated, but this is a photocopy, Lordship. That is been mentioned in the court, sir.
No photocopy, but certified to be true copy is his own.
Exhibit means what,
That-
Your Lordship?
That is not.
Authenticity of the document before the trial.
He-
it is-
Where is the cross-examination of the claimant?
It is there, Your Lordship, in the claimant of the Rehana Begum. He also mentioned no, nothing.
No, in the cross-examination. Where is your question?
Lordship, paragraph 6 of my judgment.
Yes,
On close scrutiny of the documents placed on record, a lawful doubt facts have come to the notice of this court regarding genuineness of the ticket. Photocopy in place on record as Exhibit D.
Hmm.
Below this photograph of ticket, it is written by signed by Insars Lanka GRP police that the said railway journey ticket being so and so is handed over by the Farid Ali relative of deceased Toibu Rahman on 24/2. There's a two persons.
Exhibit D is.
One is the IO and another is the Farid Ali. These are the two persons who can speak the truth. That is my observation here.
Exhibit D is not mine in here, the judgment copy, where the written and signed by the Insars Lanka. I have submitted the plain copy with the signature of Lanka, exhibited D. That is my copy. DRM submitted that ticket.
where is the evidence of the defendant? Of the opposite party? Did you adduce evidence, Mr. Boyd, Dr. Boyd?
Yeah, report is the our side and it has been quoted in the inverted comma in the judgment, Your Lordship. It has been reflected in the paragraph 5, issue number 1. Before proceeding in the manner, it is relevant to examine the senior DSC report landing, which is just understood. It is there, Your Lordship. Up to during inquiry, the last no recovery of the any ticket journey from the victim. That is the statement. It has been quoted here, Lordship. That report was annexed on 11/2/2014, Your Lordship, by Senior Divisional Security Manager, NFA, Railway Landing.
Which report?
DRM.
Report. 11/2/2014. That is there in the record, Your Lordship. Otherwise, I can show you here. The statement which have been enclosed in this judgment, paragraph 6, that is there. All the things have been quoted from the top to bottom.
Any case law on what is the manner of degree of proof which is to be adopted by a tribunal adjudicating a matter of claim, that claim, or claim due to accident, railway claim? Is it the same nature, same degree of proof?
I have Supreme Court, I have many citations of Supreme Court.
What does it say?
They said that
Now, what is the principle laid down? Tell us.
findings though. That this is, if a deceased was not a bona fide passenger, if the deceased had traveled as a ticketless traveler, one would normally expect the railway authorities to have detected such ticketless traveling. When a person dies in an accident by falling down from the train, it is not possible for the legal representatives to produce the ticket or valid authority to travel in the train. Depending upon the facts and circumstances of a given case, the tribunal, the appellate court infer about the deceased being a bona fide passenger.
Citation. What is the citation?
What is the citation? Last judgment. The learned counsel appeared.
What is the citation?
Huh?
The case you have cited.
Mere absence of the passenger as the Supreme Court. This is the civil appeal number 3799 of.
It's not been reported. Is it reported or not?
This is not reported. No, but I have reported citations also.
Place the reported citation.
Supreme Court report.
This is a case of which year? The one you have cited just now.
2023.
Recent case.
Yes.
Name?
Kamukai and others applicants versus Union of India and others.
What is the other citations you have? What are the other citations you have?
Other citation, the High Court of Judicature at Madras.
Reported case or what?
Reported. Reported recently. It's not reported. These are not reported.
Give the Supreme Court judgment.
Case number 5656. Case number. The most of time. Case number 5 and 6.
Page 5 or para 5?
Yes.
Page or para?
Page number 5. One error is asking. Rina Devi to reported is enough. It would be. What? Rina Devi to absence of ticket. Divide. I have reported case here, Rina Devi.
Our High Court.
No. Supreme Court. Case number 6, paragraph 9. Case number 6, paragraph 9.
You should have brought Rina Devi. This has been referred in the Madras case.
In Rina Devi's case. Reference is Rina Devi.
Anything else? Any more? Have you read this Rina Devi?
Lordship, latest judgment has been passed, Your Lordship, by the Supreme Court. The Justice Maheshwari. The judgment says the mere absence of ticket also it can be counterpart to be a bona fide. But here in this case, there is an option, Your Lordship. Option is that there are two vital evidence. One is the IO, long IO, who certified the whatever is certificate of that ticket, and another is police. Ought to be come before the Honorable can speak the evidence. As per the procedure of the evidence act.
No, when the Supreme Court has gone to the extent that mere absence will not negative a claim, and here there was a ticket, you are doubting the ticket. Agency in a better footing. Even when in a case where ticket is not been able to be proved or produced. Even, and here police report says that he died in a railway accident while retraining at a particular station.
Here in this case, Your Lordship, we have a procedure, sir. 16, section 16, claims tribunal. Even in the evidence also in the appellant, never said a single word
Regarding,
purchasing of the ticket or anything, because he is not eyewitness of that case.
No, he said,
Lordship,
no, these arguments of yours
my humble space.
is not a reply to the law laid down. Law has been laid down that even.
Right, law has gone in a holistic approach that whenever any person who have been moved from one person to another, having a ticket, it will be claimed in a holistic approach, yes.
Even ticket is not required to be proved or produced.
But here in this case, yes, something is defined, Your Lordship. In the inquest report, in the details of the inquest report, even the Fariz Ali, the person who was supposed to be added as an evidence, he himself put a signature on the dead body. He himself in the inquest report. He himself in the entire proceeding. That 11 point of time, he doesn't have a single time to collect that ticket, or any investigating officer failed mechanism to draw a collection of that ticket in that 11 point of time, Your Lordship. Because we follow the RCT procedure as per the section 16. Here in the section 16 says, Your Lordship, I may read, Your Lordship. Every application under subsection shall be in the form and be accompanied by such documents or other evidence. That is the answer, Your Lordship.
Here, ticket was produced by whom?
Ticket is produced by IO. He says that Fadiz has given to the investigating officer, and the investigating officer given report certified that this is certified to be true copy. That ticket. After that, this judgment which has been passed by the trial court, afternoon one man back. The trial court says that the ticket which has been received in the police report in the separate entity, it is found after 1 month. That is the point, Your Lordship. The question of doubt on point of issue on that relevant point of time, assuming we later about the Fariz Ali, the investigating officer of that the department, the government machinery, what we have to search all the things before going to the
Suppose the worst case, there was no ticket, then
Lordship, in that case,
there was
also,
no ticket. Ticket could not be produced, but there is a police report.
okay. No, Lordship, what is happened? If there is no ticket, we stick on section to our passenger in the railway ticket, it's been mentioned here category.
No, vis-a-vis the Supreme Court ruling, we are only trying to understand or get your response to that. In a given case, there ticket could not be produced.
Now, I don't know, my department has challenged that order or not, I don't know. That is, there is a limit.
Which order?
The Supreme Court judgment which has been passed, I don't know.
Supreme Court order is challenged where?
In the
In
constitutional bench.
America.
No, it is maybe in the constitutional bench, but I do not have seen it.
the issue has been settled by the judgment of Rina Devi. But in that case, the Supreme Court has said that mere absence of a ticket is not dispensative claimant.
Yes,
But in the absence of a ticket, my lord, there has to be other oral evidence which has to be brought on record to suggest
that is
that.
exactly we are trying to put.
that
There,
is the-
there's a police report which says that the death occurred while alighting from the train. The death and his body was found there.
on the railway track. That fact is accepted, my lord. That doesn't prove the fact that he was having a valid journey ticket, my lord. So in the absence of a journey ticket, the claimant side.
No,
has-
if the Honorable Supreme Court has gone to the extent that production of the ticket may not be a sine qua non, it may not be sacrosanct.
that there has to be adequate pleading in the,
Ratings what? Regarding what?
regarding the fact that the person had purchased. the
See,
ticket.
wife, he still not know
That is what,
husband was going by which
that
train.
is the ratio of the Supreme Court. my
No, can a wife know if she was not accompanying?
lord.
Is it a genuine, is it a reasonable approach?
There can be other persons.
A person goes out of the
There can,
house,
my
he has
lord,
got business to attend, he alights a train.
in a train, my lord, person doesn't travel alone, my lord. There are hundreds of other
You
passengers.
don't travel alone in a train.
But
I have traveled alone in a train for how many times I do not know.
I'm not saying that, my lord, there are other persons in the train. my
Don't
lord.
even know anyone in the train.
Maybe, but that is the ratio.
That is not.
That is the ratio of the Supreme Court and followed by a Honorable High Court also. There are 3 judgments following Rina Devi. Delivered by.
Rina Devi we were only discussing.
Following Rina Devi, 3 other judgments have come from our Honorable High Court, my lord. And it has said that in the absence of a ticket, there has to be evidence and pleading in the claim petition to show that the person had purchased the ticket. I can give the citation. It's Kaliram Kaur and Rukmini Chauhan, 2 judgments from our honor. I had appeared in, those are reported cases.
Is it a reasonable approach? Wife
Otherwise-
doesn't even know he was traveling.
otherwise-
And it's very easy for her to say, make a statement, yes, he had bought a ticket. What evidentiary value will it have? He was not even there.
Then we can question her in rebuttal, my lord. The person.
That is it. Is there really evidentiary? How did she know that he had a ticket or not?
That is
Unless the
thing, my
ticket
lord.
is produced.
That is the
Here
thing.
there is a ticket. Here writing the authenticity of the ticket.
I have also found cases, my lord, where tickets were not available. It was not found, but persons, my lord, had deposed on affidavit before the tribunal saying that that person had seen the person concerned buying the ticket, and on that basis,
That is a very weak,
there are a number of cases, my lord.
that's a very weak piece of evidence. It's a
But that is
manufactured
the
thing.
issue of the honor of the court.
We won't go by a mechanical approach. Very easy for somebody to say, yes, I saw him buying the ticket.
And thing is, my lord,
Is there a credible witness? That
if it is not followed, my lord, then there will be difficulty, my lord. Any person dying on a railway track, my lord, would claim it.
police report, they'll just give like that.
Police report is actually the,
Is by your police.
no, it's.
Yes,
police is
CRP.
GRP is not railway police, my lord, it's Assam police, my lord. Governed by the Assam.
Nonetheless, an authority,
Yeah.
not by some
In
private
terms of
body.
the Railway Act, my lord, what is relevant is the DRM report. It's
There
a
have been-
mandatory requirement, my lord, it's a statutory report. In
Let us
terms of
see the
railway.
DRM report again. Let us see the DRM report again.
Even if Lordship go to the NPSC portal, is fine on that day. It is mentioned in the judgment, your Lordship, in the by quotation, in paragraph 5.
Please read again.
Page 3, with reference to the above, it is submitted that the subject case was inquired by the IPF CPK. And after completion of inquiry, the detailed report has been submitted, which reveals that on 21/1/2013 at about 9 AM hours, a memo was issued by one duty ASM LKA mentioning that one unknown male person aged about 45 years has been fall down and run over a train, so and so Nagaland Express, while the said train passing through LKA railway station, that is Lanka railway station. In line number 2, on getting information on duty RPF and GRPF staff attended the site and immediately injured sent to the civil hospital, Lanka, for treatment. After rendered the first aid, victim was referred to the FRU Huzai for better treatment, but the victims come to his injury on the way to the hospital. During preliminary inquiry, the victim could be identified as Toibur Rahman. He is about so and so. Later on, the body of the deceased was sent to the civil hospital Nagaon for the postmortem. In the postmortem report, the cause of death has been shown as due to shock and several hemorrhages from limbs, legs, and crush injuries of both legs. In this regard, OC GRP Lambring registered a unnecessary death case number 2/2013. After completion of the investigation, FR of the case has been submitted on 31/8/2013, showing the case as an accident 1. Now relevant point here. During inquiry, EO has collected all the requisite particulars from the concerned GRPF office and SS office. Further, in the letter of CCM, FM Court and Maligaon, the date of incident is mentioned as 21/2013, but from all the record, it is established that the incident of Toibur Rahman took place on 21/1/2013. Further, it could not be ascertained whether the person was bona fide passenger or not, since in the report GRP it is mentioned where
It is not mentioned.
not mentioned anywhere regarding the railway ticket any journey from
Ultimately, it boils down to the recovery of the railway ticket.
Republic. Now, actually, you're also the incident took place on 20, not on 21.
Not he.
Here, the incident took place as per the DRM report. The incident is mentioned on 21/2013. Thereafter, it was been entrusted to the police investigating officer. And your lordship, in the inquiry report, I found your lordship.
It is 21st. The tribunal came to a finding that from all records, it is established that the incident is of 21. There was
21.
some error in writing of the date of the incident as 20. It is 21st.
Now, I have seen your lordship, the report of the untoward incident by the railway, your lordship. It has been mentioned of the Nagmani Mandal. If you see, lordship, the details on 21 January, the case diary.
He boarded on train.
See, he mentioned all the things, your lordship. He mentioned all the things, and thereafter, interest form report. Diary notebook on your lordship on 21 January 2013. All the things he has been narrated in the 11th paragraph, your lordship. Point. One unknown male person is about 45 years lying on the so-and-so yard. Their leg has been so-and-so.
How far is Badarpur from Hojai?
214 kilometers. 214. He boarded on the train on 20, and the incident happened on 21.
In the report of the inquest report also said here, lordship, only the injury part. And thereafter, he was transported to Huzai, then Bongaigaon.
See, if you look at the ticket, exhibit D, the ticket was purchased on 20th of January 2013 at 19:03 hours at 7:03 p.m. And the date and this report is of 21/1/2023 at 9 a.m. So this is not unreasonable. The date, there is no anomaly with the date.
If the order sheet says about the, I don't know about LCR, if the order sheet says the court has summoned to the Paris Ali and the IO, in spite of repeated requests, they have not turned down the request before the evidence. Then we can see that, yes, what is the, whether it has been categorically mentioned about the allegations which have been passed by the guideline. Order sheets of the RCT on issuing of summon to the, your lordship,
Yes,
IO.
just a minute.
I don't know. I will look it now.
IO had deposed.
No, he's not the IO. He has done only the final report on the basis of the case diary.
Ronnie Guyon, your lordship.
Bharani Gayan.
Attorney Gayan was what?
He has completed the final report. Put his
Oh, but he
signature.
was not the IO.
Not done.
IO was Satyendra.
September from.
And he was called on 3 occasions. Initially, Attorney Gayan had appeared.
Lordship.
He was called on 19 on 17. He appeared on 21 to 17. And it was deemed fit that the original IO, Satyendra Som, should be called as a witness. He was called, press summons on 5-4, press summons on 8-6. He did not. And on 13-7, the court tribunal has made an observation that since the photocopy of the case records are there, case diary is there, so the court tribunal has proceeded. The tribunal has also made an observation at paragraph 10.
Lordship.
Please read 10.
All these facts narrated here in above clearly show that the preparation of this police report exhibit A series is nothing but an afterthought and possibility of planning a ticket later on cannot be ruled out.
Was that your case?
Lordship, what about the available records, attempting to
No,
investigate?
no, we are not saying that the tribunal is not entitled to make this remark. But was it your case that you're doubting the police report, there was no accident, it was a plaintiff's case?
Yeah, the thing is, there is no doubt about it, but the issue remains of the conscious position of the ticket on the part.
No, the observations made that is nothing but an afterthought, possibility of planting the ticket.
Yes, there is a There are lots of possibilities in one sense.
No, you did not put a cross-examination, in the cross-examination, you did not put a question to her.
But he said no in the cross examination. What I have said here last now, that she doesn't know anything because she's not eyewitness of that case.
No, you could have given a suggestion, he was traveling without a ticket.
No, one statement she mentioned that in the evidence and affidavit, I see my husband was traveling from
Yes.
my husband was traveling with a very ticket journey.
Yes.
In the cross examination, she said she doesn't know anything. As far as statement of the cross examination. So there's a contradiction on the exemption slip and the cross examination. Itself in her claim. It is been mentioned here. One statement exemption slip, she said that there's a traveling ticket. In cross examination, she denied that she doesn't know.
Is not.
Where is the denied? Let us see.
She said that I don't know nothing. As I reviewed out.
Let us see, let us-
Let me see the cross examination again in yellow. So I will try to point out what is there in the.
That is not correct. I am not an eyewitness of the case. I have not seen my husband purchasing the ticket and boarding the train, Nagaland Express. This is not a,
The same thing seen in the exemption, she said that my husband was traveling with a valid ticket journey.
no, you had made a suggestion. It is incorrect to suggest that I have deposed falsely before this court.
This is the statement which has been mentioned, Your Lordship.
She has not seen.
That's the point, Your Lordship. If she has not seen, then how can she exhibit?
That is a different, she has not exhibited. It's from the police.
No, she has
That-
mentioned in her
it's a
statement that
certified
Your
copy.
Lordship, ticket is a exhibit D, paragraph 4.
It's from the police.
She has also made deposed a statement in Your Lordship in the one paragraph 4, Roman 4. Ticket is as exhibit D, Your Lordship, in exemption sheet, depose on
কৰিব লাগিব আৰু।
4th April 2016. If I rely on the cross exemption, then what is the part of the exemption sheet? If I rely on the exemption sheet, what is the part of the cross exemption sheet?
Documents should be exhibited with the affidavit in
There is a two
evidence.
contradictions, Your Lordship, in this part. Her
And-
own
and-
itself,
And she saw the ticket
I assume, Your Lordship, these are the statement which have been claimed as not an eyewitness. Only two part evidence. What my learned friend said, if there is alternative remedies that oral evidences in the as part of evidence of the section 16 of the Railway Claims Tribunal 1987, there must be a follow procedure. If these two persons ought to have placed before this honorable court and give the deposition, then it is a different. But here in this case, Your Lordship, the attempt have been made, response have not come. Even he has certified the copy. What does it mean, Your Lordship? How far from the distance from the investigating officer and our city? Within the jurisdiction of Assam. Because it is Assam state government.
She cannot force an IO to come.
No.
Summons were issued on 3 occasions.
So that is the part, Your Lordship.
That is the fault
My
of
humble
the-
service.
Can they be faulted with this? If an official witness fails to come after 3 summons on 3 days.
I have a good observation in my profession, Your Lordship. In POSCO cases, well, the defense witness have to come as an official witness to go before the court. Then court has asked for, party has asked for the given notice legally so that the official witness will come, but it is not happened. And I have this type of matters happen. Here in the same cases happen to her also. 241 of the evidence sector. Can we impose government witnesses to become as a defense as a DW1 or DW2 for him?
No, not for her. That is respondent.
My humble submission is that, Your Lordship, again, I come in a nutshell point here. There is no, when I assume it is a valid ticket, Your Lordship, there is a lots of thousands of question marks on this ticket. One point is that, Your Lordship, in this case, Your Lordship, if there is a conscious possession, assuming, Your Lordship, she is an innocent on that person because she is not eyewitness. The other government machineries are there involved in these cases, and the inquest report of the details given point wise.
Where is your, do you find a written statement here?
Yes, I have given in a written statement. My written statement by the department officer, Your Lordship.
Yes, sir. Which page, madam?
Written statement, annexure to page number 14.
On four.
Yes.
By Deputy Chief Commercial Manager, Your Lordship, that is on 9/4/2015.
Yes, please.
A written reply for on behalf of the most of the year.
Yes, please.
That is, may I read, Your Lordship? One, that a statement made in paragraph number 1, claim application is not admitted for want of knowledge. Number 2, that the contents paragraph number 2 of the claim petition is not admitted for want of knowledge. Application is required to submit strict proof of demand thereof.
No.
Number 3, that the statements made in paragraph 3 of the claim application is not admitted for want of knowledge. The application is required to put strict proof thereof by way of an affidavit in support of the statement as mentioned in the made paragraph 3. Number 4, that the statement made in paragraph 4 the claim application is not admitted for want of knowledge. Number 5, that the contents of the paragraph of the claim application needs no comment. Number 6, that the statement made in paragraph 6 are denied. The GRP report has clearly mentioned about the incident that the deceased person was trying to get down from the running train. This is clear case of negligence on the part of the deceased victim person, and hence railways are not responsible for any kind of the victim or his or her negligence, which amounts to be self-inflicted injury as per section 124A, Lordship. In this ground, the claim application may be dismissed. Number 7, that the application made in paragraph of the 7 of the application is made matter of record and verification of the ticket. The application is now submit the strict proof of bona fideness of the ticket as a passenger under section 2 of 29 of the Railway Act 1989. That's the point, Your Lordship. Number 8, that the contents of the paragraph 8 of the claim should need no comment. That the 9, that the contents of the paragraph 9 of the claim is not admitted. The application is required to submit strict document evidence thereof. That the contents of the paragraph 10 of the application is needs no comment. That in respect of paragraph 11 of the application needs no comment. That 12, that in respect of 12 of the respondent offers no comment. That in respect of paragraph number 13 and 14, respondent offers no comment for want of knowledge. In paragraph 15, regarding relationship with the deceased is stated by the application's husband without producing any supporting documents, and the application is put to prove the valid authentic documents in connection with the relationship of the application with the deceased. So all the things have been narrated, Your Lordship, from up to.
What is narrated? No comments have been narrated. All
Yeah.
or no comments, want of knowledge.
No, Lordship, in this point here.
There was a single statement, affirmative statement of denial, except 14.
Sir, Your Honor, in the paragraph 6, what I try to please before this honorable court. Assuming, Lordship, if he has a bona fide ticket also, if there is a
This
mere
is a
negligence.
different point. You have said, this is a different point altogether. Evidence has not gone there. That is a case of negligence on the part of the deceased, and therefore you are not liable to pay.
Lordship,
That is not the point at all.
that is the point. My humble submission is that the sustained injury of the inquest report shows in that way, Your Lordship. The injuries, the part of the injuries on that
Is the
part.
denial on that part, on that point, that it is the negligence of the deceased.
We cannot say,
Then why are we taking a point? This is their appeal.
that's the point, Your Lordship, but whatever submission by this, by my,
This written statement is no written statement. Want of knowledge, no comments.
the passing of this James 20 and trial court has passed out there. My humble submission is that I will speak on the paragraphs 5, 6, and 7. What about the mention about the details in report, Your Lordship? What the investigation is in part in the issue number 1, 2, and 3, 3 and 4, Your Lordship.
Anything else? Any judgment?
I will let know the record have been placed for me today only, sir. Anyhow, else I will place my judgment if possible. My humble
Well.
submission, only one point, Your Lordship. Since there is no conscious possession of the ticket, either from this side or that side, in the inquest report or police report or any report which have been mentioned, Your Lordship, the ticket which have been found after 1 month back. This put a question to us whether that ticket is genuine or in the custody of the deceased person or not. While there's a two-part, Your Lordship. One day meet at Lanka and another meet at another hospital. They went from the preliminary inquiry, then we go to the, in that 11 point of time, in the point of meeting with the deceased person in the hospital, there is no recovery of the ticket on the backside. There has been no mention in that part. Even in the inquest report also, in details and as well as in the case diary. Now, the SOM which have been given that contradicts the statement which have been passed by his own statement in the EGR report and officer. So my humble submission is the paragraph number 5, 6, and 7 and 8, what the trial court has passed, has beautifully been explained and there is nothing left, and this case may be dismissed. That is my humble submission.
Anything, madam?
Applicant should not be suffered due to the fault of police officer. Because the Faizan Ali who handed over the ticket, he not signed in the ticket that he had handed over the ticket to him. There is no signature of F. Ali.
And if your lordship, if you permission, your
And
lordship,
the statement taken by him on 21 at time of inquest, and he, according to him, he handed over the ticket in the month of February, and his statement is on 21/1/2013. So at that time, he has not given any statement, or police did not take any statement from him.
with your permission, your lordship, if I
There is
have
no statement about
I
how
have
he
the
handed-
specific ticket on by name, then this
No,
person
police-
never arrives. But
police-
General ticket.
this is general tickets. This has happened, your lordship. I never think it, I never lenient on the our part also. The issue is that, your lordship, all cases, if it is not, if you go now in railway also, we're trying to evict the people, and there are lots of cases to betterment of the upliftment of the welfare of the state of the railway. Now these things happen in also. The same thing is happening here also. In station, if you see overcrowded, so every overcrowd, or if you come a person in a track line also, how railway can safeguard all from one point to another bottom, sir. So this is a vital issues we are trying to rectify from our department side. But my humble submission, this case never come in a rare of the rare case that is happened. Is happen in a general happen, and and if there is a conscious position at that 11 point of time, I have no case.
Respondent.
That is my humble.
Respondent did not say that the ticket is fake. Ticket is not genuine.
Your name, madam?
And Ahmed.
And
Ahmed.
Ahmed.
Yes.
Or MS and Ahmed. For the
Is the one in the Supreme Court.
also Dr. P.N. Kukut. Learned. Railway Council.
Lordship.
Understanding Council. Railway. The hearing is concluded. Judgment.
I'm deeply obliged. Your Lordship.
I sincere apologies, Your Lordship. This matter, when the petitioner was shown as ACB, Your Lordship, and our names were also not shown.
Yes.
for this. Otherwise,
ACB is not enough.
actually, there was a lapse on our part. We missed the matter, Your Lordship.
It's a already old matter. Come
Yes.
prepared.
Lordship, just one aspect, otherwise, I had a opportunity to go into the brief, go to the appeal which was filed by AACB, because two appeals have been filed. One is by the house owner and one
Correct,
by
correct.
us. Lordship, it appears that in unfortunate circumstances, the life has been lost, Your Lordship. A very small amount is involved. If Your Lordship grants me some time, I'll try and advise my clients if,
No, we'll have it next Tuesday. In the meantime,
yes,
if
very
you-
well. I'll get my
If you take
instructions.
the instructions well and good, otherwise we have seen it.
Yes, Your Lordship.
And those were the matters where the approach was slightly different. Now
Yes,
we don't have that approach.
yes, Your Lordship. So,
If the accident is not doubted, then little bit here and there.
yes, if
What was the amount involved that time?
that time it was a very small amount, Your
2
Lordship.
lakhs, I think.
No, this was even prior to 1 lakh or something. Now I think the court had, I
Now
think
I see it's 4 lakhs, isn't it? Now
4 lakhs to be divided between both the house owner and the ACB. So I think we have already paid 150,000. So around, just a small amount is involved.
Tuesday.
So I'll try and advise them to withdraw it.
Your appeal is for what?
I mean, item number 9, your
No,
lordship.
no, no, their appeal.
No, the other is by the homeowner, your lordship. The amount was to be.
Who's there? Who's
May
for the appellant?
may I appear there?
D. Chakraborty, KB Chaudhary. Y. Imran. Where is Chakraborty? Dipanjan Chakraborty. Three. KP Pathak, Planet Council, representing the ACB. Submit that due to inadvertence, the matter was left out and prays for a small accommodation, by which time, he would also seek his work if any settlement, if any broad terms of settlement can be placed before this. Sarah? Considering the above, matters are directed to be called, to be listed on Tuesday. Tuesday.
Publish.
Madam Tuesday.
No, I've gone through the court records, my lord. This is an appeal by the railway, my lord. The appeal is on a very narrow campus. my lord. What has happened, my lord, the petition, the respondent herein, he was a victim of untoward incident in the Dimapur railway station. In 2004, my lord, there was a bomb blast in the Dimapur railway station, and in the process, he was injured. Subsequently, based on the injuries, he had filed an application before the Railway Claims Tribunal claiming compensation, my lord. And he was granted an amount of rupees 2 lakh as compensation. There are two components to the award, my lord. Number one was with regard to serial number 26 of schedule 2 of the Railway Compensation Act, and the other one was other amount for rupees 80,000 was a combined amount for different injuries sustained, my lord. That was a non-scheduled injury, my lord. Now, the award was passed. Railway had made the payment, my lord. The matter attained finality out there. Thereafter, after about, my lord, the award was passed in the year 2007. Subsequently, in the year 2009, based on a certificate issued by the civil surgeon of the Dimapur hospital, he files a miscase before the Railway Claims Tribunal, saying that the injury for which was granted 80,000 as compensation, that has aggravated and it has resulted in permanent disability. So he filed the miscase for enhancement of the compensation. Now, our case is, my lord, whether it was open for the tribunal to open the case.
Reopen.
Number one. Number two, my lord, the tribunal had resorted to sub-rule 4 of Rule 3 of the Railway Accidents and Untoward Incident Rules for coming to the conclusion that the miscase is maintainable. That rule itself is not applicable in the case, my lord, out here. I'll point out that. And number three, the most vital aspect, my lord, the certificate based on which the compensation award was enhanced, my lord, that doctor, although was summoned, my lord, he never appeared before the court, and that document remained unproved, my lord. Forget about giving us an opportunity to cross-examine the doctor. He was never examined, and the document remained unproved, and the person concerned was never examined by the railway doctors. So on these premises, the railways have preferred this appeal.
How much was the enhancement?
2 lakhs.
Initially, it was how much?
2 lakhs, my lord. For permanent disability or death, it is 4 lakhs, and for injuries, there is a schedule prescribed, my lord.
You said 80,000.
My lord?
You said 80,000.
For non-schedule, it's 80,000, and for the schedule, for various injuries, the amounts are different. In case of the petitioner, for loss of vision, he was granted 1,20,000. In terms of part three of the schedule, serial number 26 and 27. I can hand over the book, my lord.
Yes, madam, what do you say?
So,
Lordship, in this case, Lordship, the certificate exhibited by the claimant, my lord, that was based on the certificate which was placed before the tribunal in the earlier litigation, my lord. That is 1810-2004, my lord. That
1810 was the original certificate.
original certificate,
Now, this certificate upon which you are basing your announcement,
yes.
was that certificate proved?
No. Yes, lordship, this injury is consequential injury to both ears, my lord, which led to loss of hearing, my lord. In the
Yeah,
earlier
understood.
certificate, it
In
was
understood,
mentioned,
in absence of the subsequent certificate, if
It
you
is-
say there is a consequential injury,
yes, lordship.
unless the subsequent certificate is there, can you prove it? You cannot.
My lord, may I submit? My lord, I have a citation of the Honorable Supreme Court, my lord, where it is clearly mentioned that if it is a consequential injury, my lord, which led to the earlier document, based on the earlier document, my lord, then the claimant will be entitled to get the relief, my lord.
No, getting relief is not a issue. You
That's
get the
cer-
relief, but aren't you required to prove it?
My lord,
Supreme
another,
Court has said it is not required to prove the subsequent development.
but the doctor was not never summoned before the court, my
No,
lord.
it's wrong, my lord. He was summoned.
No, my lord,
I
No,
can
my
give it's on record, my lord.
he was never summoned, my lord.
They have filed a memo on page number 13 of the LCR, my lord, is the memo filed by them, and page 14 is the summon.
What is the citation you are trying to rely upon?
First citation is, my lord, it's the reported judgment 2013 4 Supreme Court cases, SCC 270, paragraph 11 and 13.
2013.
2013 4 SCC 270, my lord.
Name?
Name is, my lord, Sandeep Kumar Chaurashia versus Divisional Manager, the New India,
Paragraph?
paragraph 11 and, my lord, 11 and 13. I have a copy now.
There is a report of the medical board here.
My lord.
There is a report of the medical board constituted by the consumer forum.
In this case, my lord, that certificate which was exhibited by the doctor, my lord, that doctor is also from the have a look, my lord. This certificate which was subsequently exhibited, my lord, that certificate was also issued by the Deputy Chief Medical Officer, Civil Hospital, Dimapur, Nagaland, my lord.
That is not the issue. Here, paragraph 11 says
Yes.
that though the report of the medical board constituted in furtherance of the direction given by the state commission.
But, my lord, in this case, the doctor was never summoned, my lord. And my lord, when the order, when the honorable tribunal, my lord, heard this matter.
See, your entire claim is based upon a certificate by a doctor.
Yes.
Isn't it your duty to have the certificate duly proved?
He has filed his affidavit in evidence, my lord.
Who?
The claimant.
Claimant, not by the doctor.
Yes, sir.
Claimant has got the certificate. He is not the maker of the certificate.
In that regard, my lord, I also would like to rely on another judgment, my lord. This is also a reported judgment. It's an old judgment, my lord, 1989, 4 SSC 286, my lord.
This is a case of what nature? MSCP? What?
This
No,
is
no,
a
your
writ
case,
petition.
your claim,
This is the MFA, my lord, pertains to railway accident.
railway. What is the citation?
This is 1989, 4 SSC 286, my lord. In the case
1989, 4 SSC.
286. In the case of Pandit Parmanand Katara versus Union of India and others.
Yes, what is it?
Here it is held that, my lord, lawyers, police and courts exhorted not to call the doctors for evidence or interrogation unless absolute necessary, and when called to treat them with respect and not be able to wait for long or suffer harassment. My lord, in this case,
But that is the general proposition. We are fully agreeable.
here,
But here, you are making an announcement based upon a particular certificate.
Yes.
It is not a case that you have met with some accident, doctor has given a certificate, doctor not called. And tribunal may say it is not required. You are proving the, but here, after compensation has been granted, you are seeking announcement on the basis of aggravated injury based on a certificate, and to prove that you have a certificate. Under those circumstances, would it be necessary to have the maker of the certificate examined, give them a chance of cross-examination?
my lord, in this case, that certificate was never reputed in the written statement of it. It was
That
never
is also
disputed.
there, my lord.
No, my lord, it's a mere denial, my lord.
And
Mere
the
denial.
doctor
They
himself
could
was
have-
summoned, my lord.
They could have, my lord, asked for summoning the doctor, my lord.
They have themselves filed the memo for summoning the
And
doctor.
in this regard, we have also
And it is
filed
there on
affidavit
record,
in
my lord.
evidence, my lord. That was also not challenged. At the time of hearing of the maintainability of the application, my lord, their submission was not recorded, neither they have disputed anything in this regard, my lord. May kindly see the order, my lord.
Which is the impugned order here? Dated
27/8/2012.
earlier, you were paid 2 lakh, 120 plus 80.
80
Then by the enhanced, what has been directed?
for the 2 lakhs. And that too based on a rule, my lord, that is not at all applicable in this case. In fact, in the Railways Act, there is no provision except sub rule 4 of rule 3 for enhancement. And sub rule 4, my lord, says, I'm reading it out, I'll hand over the book, my lord. When compensation has been paid for any injury which is less than the amount which would have been payable as compensation if the injured person had died, and the person subsequently died as a result of the injury, a further compensation equal to the difference between the amount payable for death and the already paid shall be payable. It is only in case of death. There is
When
no
the
other-
injury ultimately culminates in a death, the case of death, then
Death.
only you, there is a
then only.
proof
my
for
lord.
enhancement.
And this particular provision has been invoked to enhance the compensation. my lord. This
Where-
is not at all relevant and applicable. my lord.
Where is it?
My lord, I've handed over the book. And the schedule is also there, my lord. The 80,000 which they have paid, it's based on sub rule 3 of rule 3.
Apart from 3, 4, there is no statutory provision.
No, for enhancement. Only in case of death, if that injury subsequently results in death, that is the only thing. Then the full compensation can be granted.
For any other event where subsequently it is seen that more damage has been done, but there is no death.
I'm
Is
not,
there any other issue?
I'm not coming to. It's not that, it's not there.
No, in a given case, that cannot be there.
They might not have imagined such a situation, my lord.
In such a situation,
That's the thing.
maybe 3, 4 may not be applicable, but
But they've invoked,
tribunal cannot be made powerless.
no, I understand, my lord. I'll not object to that. I'm just pointing out that that provision would not be applicable. But the fact remains, my lord, that the doctor was summoned on their application. The document has to be proof, my lord. At least we should be given a chance, my lord.
Where is the discussion? Discussion in the judgment?
My lord, I
There
don't,
is no
Hmm?
judgment starts from page,
One second.
there is no discussion. Actually. The second last and last paragraph of the judgment might be relevant.
One. Just for brief. There is no discussion.
No discussion. Nothing. And even the issues were not framed. The tribunal is required to frame issues while disposing of an application in terms of the,
Is there any stay order here?
yes, statutory provision is there regarding framing of issues.
No. Is there any stay order here?
Yes, there was a stay order initially. I was not the counsel who had filed.
Doesn't matter.
Initially, there was a stay order. I've gone through the record.
Lordship, in this case, another judgment is kindly be perused. Paragraph 25 is very much relevant, my lord. Which is also a reported judgment, my lord. Paragraph 25, my lord.
Name?
Name is, my lord, Rathi Menon versus Union of India, 2001, 3 SST 714.
On a different context altogether.
My lord, here it is mainly that whether the claimant can claim compensation twice, my lord. This is on that point, my lord. Paragraph 25 says that.
Madam, we are not on that. Because we have read this judgment. Initially, your application was placed before the division bench
Yes.
of the tribunal.
Tribunal, yes.
Tribunal bench opined that yes, it is maintainable. So on the maintainability part, we are not too much on it. We are only in the part of whether you are, not whether you have proved in accordance with law.
Okay.
We will not say whether you are able to prove. You may still be able to approved. But whether yet adopted, the proper procedure are adopted.
My lord, in this case, the doctor had issued certificate on the basis of the audiometry report. That audiometry report was never challenged before the honorable tribunal, my lord. Audiometry report is in the record, my lord. Is also exhibited
the-
with the memorandum of appeal.
The enhanced compensation is because of the finding that there is absolute deafness of the both ears.
Yes, my lord.
That is not a part of the audiometry report. That is a part of the certificate.
My lord, may kindly
Certificate
be
says that
perused the audiometry.
he was and is a victim of bomb blast incident, impact of which led to the absolute deafness of both ears.
My lord, kindly see exhibit A3 in the memorandum of appeal, my lord.
A3.
Yes, my lord, it's the audiometry report, my lord.
Page
Page, may it be, my lord, page 25 of the LCR.
LCR.
Yes, my lord.
This is your claim petition.
No, my lord, it looks like this, my lord.
No, not page a bit different. Where is your new certificate?
Next page probably. The
How?
next, after the audiometry report probably.
Whatever to your not looking at. Okay. Page 23 is not there, madam.
May I see the LCR, my lord?
Just show us the pattern. How is it? Just now I have shown the
Yes. The audio brown report.
yes. Yes, 25.
Yes, 25.
Yes.
Here, my lord, the air conduction threshold left side ear, my lord, 100 dB. And right hand side, 100 dB. Then bone conduction threshold, my lord, left side, 55 dB and right side, 55 dB. Now the conclusion is, my lord, left, right, no response. And the same doctor had issued this certificate, my lord. That is certificate dated 8/9/2008.
No, these are symbols. No response, these are only symbols to be used.
But my lord, when air conduction threshold says left side 100 dB and right side 100 dB, it's below the, like, my lord, below the level, my lord.
But initially it was not given that you have suffered 100% deafness.
But my lord, in the injury certificate, my lord, we have mentioned that we have both hearing deficiency.
Hearing deficiency has been said,
Yes, my lord.
but now it has been stated, certified that you are suffering 100%.
100% deafness, my lord.
Where is the certificate?
It's exhibit A1 and A2.
New certificate.
Yes. A1 and A2. There are two certificates, my lord.
A1, A2.
Dated 8/9/2008. It's in page 26, my lord, of the LCR, page 26.
What is the date?
8/9/2008.
But this has not said 100%. With severe hearing loss.
No, one more certificate is there, my lord. A1, exhibit A1.
Here only before.
Lordship may see from my file.
Yes, yes, of course. This certificate is given after 4 years.
Yes, sir.
You have said that it is based on the same audiometry report.
Report.
But that audiometry report is of the year 2004.
No, my lord.
No, the injuries were of 18/10/2004 and 28/11/2006. When was the bomb blast? It was on
2004.
October 2004.
Yes, my lord.
This certificate is of 2008.
Yes.
The initial.
After filing of the enhancement petition. Oh, sorry, prior to.
Prior to, only on the basis of this,
Okay.
you have filed enhancement.
Yes, ma'am.
So this is done after 4 years of the initial injury report.
Yes.
How are you making a statement that is based on the same audiometry report? It may have a reference, but without a fresh examination, how can you say? If the same audiogram was the only factor, initially only it has been said that you have lost complete sense of hearing. Doesn't say so. Initially it was that both hearing deficiency.
Yes. Which led to absolute
Now-
definite.
Now it is led to absolute deafness of the ear,
Yes.
both. Yes, Mr. Sharma, what do you do?
This is on the face of it, my lord, the judgment is not made.
Don't know, we are that, but on a different footing altogether. If this has actually happened,
I also do not want that the person should suffer, my lord.
I think
What I would suggest, my lord, let the matter be remanded back to the tribunal. And the tribunal should comply with these procedural aspects while deciding the matter.
because the entertainment is not an issue for us. And the tribunal has also made the observation that it was the entertainment part was already taken care of by the judicial.
Although that finding is wrong, my lord, I will not.
We are not going.
I'm not disputing.
Since that is
I
not
don't
the-
want the person to suffer, my lord, because they could not have invoked sub-rule 4, my lord.
Now, whether this doctor is there or not,
My lord, they might have the contact with, they might have the contact with them.
is he there in this world or not?
Then I don't know, my lord. I have to take instruction from my client.
In that case, my lord, they can go for a fresh audio matter.
Yes, ma'am.
But that can be possible.
That can be.
I don't want the person to suffer.
You take instructions, madam. We'll not extinguish your rights, we'll keep it open, and even if this person somehow is not there, we'll make such an observation that not come into your way of having a fresh assessment done, we can announce. But you need to prove in accordance with law.
Yes, ma'am.
And prior facade is 2, 3, 3, 4 is not applicable.
But my lord, the last judgment that I have placed, my lord, it's regarding maintainability of the application. Paragraph 25 is very relevant, my lord. Whether this application is maintainable or not, this paragraph 25 will.
No,
help, my lord.
maintainability, we are not raising an issue.
Because section,
In view of-
sub-rule 3, rule 3, sub-rule 4 is not as per like, my lord, the claim application is not as per that rule, my lord. So on this regard, my lord, I have.
Tribunal should not have written 3, 4.
Yes, my lord. But now he has submitted before this court, my
No,
lord.
no, rightly he has submitted.
Yes, ma'am.
3, 4 is very specific of the statute, that it can be enhanced only when
Only
it
if
leads
the person there.
the injury leads to a death.
Yes.
And the initial amount given was less than what can be paid at the time of death. That's a very natural corollary. That may not be immediate, but within a few days proximate, then it can be enhanced.
But if a consequential injury, then my lord, that part may.
Consequence injury, that is why probably the matter was before the revision bench first. You take instruction, we'll have it when?
Tomorrow, so
Tomorrow.
you'll have to just get the instruction whether the person is alive or not.
No, no, you
It's better, my lord, the matter may be remanded back and a fresh examination can be done, my lord. And based on the certificate issued by the doctor, my lord, the claim will be awarded if he is.
Today
entitled.
will not have the time. We'll fix it on Tuesday or next week. We'll pass the judgment in the open court. We don't want to take this as a
Well,
part of
well,
or see. Third. Mr. Sharma, we are for the appellant, aren't you?
appellant for
P. Sharma, Senate Counsel for the appellant. Who by means of this appeal has put to challenge a judgment passed, a judgment dated 27/8/2012, correct?
probably, my lord. I couldn't-
27/8/2012.
2012, passed by the learned Railway Claims Tribunal, Guwahati bench. By the aforesaid judgment, the amount of compensation which was earlier granted by an order dated which was earlier
Probably
granted,
it's 12/1/2007.
which was granted by an earlier order has been enhanced based on a certificate issued by the doctor that in the meantime, there was aggravation in the injuries sustained. Sri Sharma has raised two principal grounds of challenge, namely that the certificate based upon which the enhancement has been paid for has not been properly exhibited, proved, has not been properly proved. And secondly, a wrong provision of law, namely
Sub-rule
Rule-
4 of sub-rule 3.
namely Rule 3 within bracket 4 of the railway accident and untoward incident rules have been pressed into service. Your Ms. Sharma, M. Sharma,
Yes, sir.
M. Sharma, Senate Counsel for the claimant, submit that the objections are technical in nature, which should not stand in the way of dispensation of substantial justice. The Senate Counsel otherwise prays for some time to obtain instruction from her client. As agreed to by the parties, this on, we'll have it on 1st of August.
Or should we keep it as part of, otherwise we'll go
No,
somewhere
this is the
else.
old matter, we'll finish it. Certainly.
Otherwise, if the bank changes, my lord, it will go to somewhere else.
No, no, it will not change. I wish it changes. Very difficult bench. Time consuming, not
Time-
difficult, time consuming.
Time to. Can I take back the book, my lord?
Yes, yes. You make a photocopy of that.
Yes, sir. I'll provide. Tomorrow, my lord, I'll provide.
Give it to our court martial.
No.
Take. But there was a partner matter. Top of the control. Top of the list, who is there? Yes, top of the list. Elementary education, anybody there? Sharma? Mr. Mahmood? You have filed your affidavit?
Yes.
Today we may not have the time, but these are matters which have been given priority for some reason. So, and irrespective of what bench we are taking. Today it may not be possible. Tomorrow, are you there? Tomorrow or Monday?
Maybe on Monday.
Monday. Paucity of time did not permit the matter to be taken up today. Put up. Then, no. However, considering that this matter has been specially assigned, this on Monday next date. No. Rest should not be possible. Not. There was a partner matter, madam. Who was on the other side? Who was on the other side?
They are
Oh, Mr. Roy was
Here
there.
is on legs, input number 12.
He is not on legs. He has gone home.
No, lordship, 8 to 12
What
is going on
will not
input
be
number
applied?
12.
Okay, we'll have it some other. It will remain in the list.
Is it possible tomorrow, lordship?
Tomorrow, Friday, we'll not know. We'll try.